What?
We have Lordship, I leave to move an urgent applications with regard to section group 9 appeal. And where the applications has to be moved by before the 25th of May, because the last date of giving the matching the bid.
25th of May? We have long crossed May.
Sorry, 25th of June. The last date
When
of
was the order passed?
10th of May.
Have you applied for certificate?
I have got the certificate copy. That's the
Then what is the
application.
problem?
But the problem is that to move it, the application has to be before 25th June.
So you give the return
But the
within 48 hours, it will automatically.
They are not, that is it.
What?
Leave may be given to, they are not accepting
Who is
by
not
48 hours. 72 hours has been given by a division bench order, that the 72 hours has to be given for listing a matter. That's why this problem, only this.
Which division bench order?
Division bench of Justice Boshak.
72 hours?
Yes, that is only problem that we are facing, And this is this 48 hours is normal course of 48 hours. But that has been given, that's why leave may be given so that I can move it before 25th.
Have you filed it?
This is ready, filing.
To file it, get the number?
Much okay.
Your lordships, may I be permitted to mention a matter?
And you have to mention after filing, you have to give the number to my court officer upon mentioning on Monday. Even if it is 72 hours, it
I do, this has been.
No, 72 hours, it comes to how much? You are filing it today.
Saturday. If I filed it today, Monday, then 72 hours, it will, the authority, the department will not receive before that 72 hours. It has to be listed after.
No, we have not heard that.
But that's I'm filing it, but I will mention then I mention in on Monday after filing, giving the number, let this matter be appeared. That's the one. And they will not accept the department. I am not on that.
72 hours notice na diye
that's the whole predicament is that 72 hours.
You are saying something without the copy of the order. You should come the copy of the order.
I
you have heard from somebody. You have said that you have not seen that order. Have you seen that order?
Yes.
You have read that
their
order.
Department is not accepting for that reasons.
Where is the order? You have.
I file it today. Then I will produce that order on Monday, showing that is. So that will not be because that's it. I will show this order.
You file it and mention on Monday. Later.
Fine.
Yes.
Your lordship, may I be permitted to mention a matter?
Why you are mentioning, madam? Have you not seen the list? Monday and Thursday we take up mentioning.
But the matter was returnable today, your lordship. But the matter is not appeared.
Remind us on Monday.
Your lordship.
Remind us on Monday. Hand over the slip and remind us on Monday. Dekhe nahi ho? Call the list. Number 1. Why to be mentioned? Oh, this is.
But I also do not know, my lord, this is that matter where lordship would recall we had preferred the appeal, and my lord, my learned friends indicated that they are not now taking electricity from us, they are taking electricity from West Bengal.
Yes.
So, my lord, it is only to be heard, my lord, the only question of law is that, my lord, company sold in liquidation. Company sold in liquidation, the purchaser comes and buys it, whether the purchaser is liable to pay the old dues. Well, it's an interpretation. This is the only short question. Any day, lordship, convenient to your lordship, it's a hearing matter.
You are relying on 4.6.4 of the regulations. They are saying under the act.
Well, it is the regulations and, my lord, interpretation of, my lord,
the act.
And, my lord, there are 2 judgments of the Supreme Court, lordships are aware, my lord.
Isha Marbles and the other.
Ramdut rulers and any day convenient, because, my lord, this will be an.
It will be an academic discussion.
No, my lord, it may be, but, my lord, for us, my lord, because this will be an issue which will be, my lord, recurring. My lord, Lordship knows, my lord, in Bengal.
When it is recurring, we'll take it up.
No, my
In
lord,
this
because,
matter,
my
it
lord,
becomes an academic
here
discussion.
there are huge dues which are there. So, my lord, that is the because, my lord, we will have to also frame our policy accordingly, whatever my lords decide. My lord, because this is my lord, especially in West Bengal, my lord, it's a common phenomenon. My lord, one company goes into liquidation, somebody else buys it, huge dues of crores of rupees. Then, my lord, the new person comes and asks for connection. So, my lord, we'll have to, my lord, also, because if the law is not settled, it is more of a policy decision we'll have to take depending on how my lords interpret the law. Any day convenient, my lord. Next monthly list also, my lord, but lordship will hear out the appeal, my lord. I can't say that, my lord.
So the paper books are there, Mr. Chaudhary.
My lord, last order, lordship said dispense with the paper books.
You
All the
dispense.
papers are there. Last order. Order to work.
All the papers are there.
Yes, yes.
এটা কি monthly combined list next মাসের combined list দিয়ে keeping it in the monthly list of July.
My lord.
Yes.
সবার আগে বুঝে না এটাই
Stated. Yes, what is the matter?
My lord, we have filed an application CAN 3. Subsequent to the filing of the appeal, there is a change in the name of the writ petitioner company. For that amendment, my lord, we have filed an application because the records has to be corrected first. My lord, they had informed us. We have given the details, my lord, the incorporation.
Application you have filed.
CAN 3, my lord, CAN 3.
CAN 3 is not in the list. CAN 3 to list. That's it. File late.
It is there in the contract.
In the cause list, it is there. May I hand
Then
over a copy of
Adani
my,
will-
it's a,
Adani Wilmar has changed to
my lord, has changed to Adani
Agri Business Limited.
Agri Business Limited.
AWL Agri Business Limited.
You are for Adani. Two
Yes.
copies. You have nothing to oppose really.
that is a fact, no?
He had informed us, that's why.
My lords, we have informed.
That is change has been after filing of the appeal.
Yes.
After filing of the paragraph during pendency.
My lord, during the pendency of the appeal, it was paragraph 2, my lord.
No.
The 16th May, they had informed us. Thereafter, we have filed an application.
Copy 10.
পেয়ে যাবে তো অর্ডার পাস করে দিচ্ছি ডিসপোজ অফ
This is an application for recording the change of name of the writ petitioner respondent number 1. So, change of name occurred on 17th
delay.
$76 stated সাথে
Opposite.
No, my lords.
আগে করে তারপরে লেটার হয়ে গেল ক্যান এটার আগে
Can ওটা section 5 টা হচ্ছে তোমার can 1.
Can 1 of 2024 is
এটা
an
কোন
application seeking
এটা কোনটা
condonation of a delay of
কতদিনের delay আছে এটা?
Right.
বাবা স্টেটের এটা
filing the present appeal being MAT number 1077 of 2024 from the order impugned dated 7/2022. 65 days. We are satisfied with the
তাহলে
grounds
এটা আগে ফাইল হয়েছে নাকি?
given in the application.
Huh?
Thus condone the delay.
হয়েছে পরে ফাইলটা কোনটা পরে হয়েছে? WPIDC ডেটটা কবে তাহলে?
Application is
এই কন্ডিশন অফ WPIDC কে দেখো কত ফাইল
করে তারপরে cancel. 7th March 2024.
কিতনা দিন?
Acha, in this writ petition was hard on affidavits.
My lords, opportunity was given.
Opportunity we did not file, madam. We did not.
Uh,
We did not
Opportunity
file.
for affidavit
Opportunity
given.
was given, we did not file. State
They
did
did
not.
not. So do you wish to use any affidavit to the stay application? What is the order about?
What are incentive schemes?
Uh-huh.
The incentive scheme.
Incentive scheme.
Well, they have been asked to disburse against the incentive scheme.
My lords, it's a
They have
2008
not-
incentive.
They have not preferred any appeal.
Well, they have been allowed. The writ petition was allowed.
Oh,
That's why we have preferred.
We have filed a writ petition that was allowed. Against
was-
that, state and WBIDC has preferred appeal.
This is
have you
basically
filed
the
any
GST
writ
regime.
application?
My lord,
My lord,
here the
contempt
question
effect.
is, when the GST regime comes into play, whether the previous tax regime will prevail or not. This is the interplay.
File an affidavit to the stay petition.
My lords, we will file.
Can not complete. Can 2 is an application seeking stay of the operation of the 635. That but an order impugned dated 7th March 2024. So, next, counsel appearing for the writ petitioner, respondent number 2 pays for leave to file an affidavit. To such opposition.
76, 65 state.
State or 76 such affidavit in opposition be filed with the receiver of
Writ petitioners আছে ঠিকই বলেছো
respondent number 1.
না রেসপন্স
Are you appearing for 1 and 2 as well?
yes এটা fine.
My lords.
Fellow petitioners, respondents 1 and 2. Such affidavit in opposition be filed within a period of 2 weeks from date, that is
2 weeks
July 3rd, 2025. July 2025, July 10th, right? So this
জুলাই ডেটটা কবে?
matter
কবে জুলাই বললি? কত WPIDC ফাইল হচ্ছে? আগস্টের
is this matter for further consideration on July 22nd, 2025.
yes next
Next is the appeal preferred by WBIDC. Against the same order, my
2
lord.
weeks 1 week 22nd July we have kept it.
My lord, the date of filing is different. This would be WBIDC.
So you have filed an application for
Condonation of
as
deal.
well as for change of name.
Yes.
Same just.
My lord, the state's delay is 65. WBIDC's delay is 76.
You are appearing for the appellant. ওটা শুধু 70
What is the date of the impugned order, Mr. Koti?
Same. Date of the important, same order has been done.
same order has been
Yes,
done.
yes.
So we can which is that item number?
My 2 and 3, my lord.
They're very good. We can hear the matter analogous.
Yes, my lord. That has to be heard analogously.
My lords, same matter.
3 matter.
Same matter.
তাহলে তুমি কস্ট টাইটেলটা এই দুটোর করে দেবে হ্যাঁ একটা অর্ডারেই করে দাও। আচ্ছা তাহলে পরে করবে, সেপারেট অর্ডার করে 22 তারিখ রিটার্নেবল করে দাও, তারপর দেখে নাও।
Yes, my separate orders, let it separate.
Obliged.
I'm grateful, man.
But I am for the appellant. Two appeals have been filed out of one common judgment. And one is appearing, but another be also appear. Both the appeal be taken up together, my lord.
When have you filed?
My lord, one is filed
What is the number of that?
559, MAT number 559, that is
Why
renumbered,
to have, renumbered as?
number FMA number 761, that is appearing.
Write down.
That is appearing.
Write down the matter which is not appearing.
নাম্বারটা মাই লর্ড লিখে নিতে বলছেন, যেটা অ্যাপিয়ার করছে না স্যার। 559টা রিনাম্বারড হয়েছে,
কত নাম্বার হয়েছে এটা?
এফএমএ 761 যেটা লিস্টে আছে, আর ম্যাট 826টা অ্যাপিয়ার করছে না।
FMA 761
559টা 769 হয়েছে একদম।
No, first listen.
আরেকটা আছে স্যার ম্যাট 826 অফ
77 কত বললে?
761,
761
হ্যাঁ যেটা লিস্টে
অফ
আছে।
25 না?
হ্যাঁ
What is the order impugned?
My lord, impugned order dated 19th February.
Subject matter.
Subject matter, my lord, by the direction of the division bench, one issue has been framed whether the plot number 13845 is a pukurpar or my claim is a bastu. That is to be
Whether
adjudicated.
it is a pukur or a bastu.
Pukurpar,
Pukur pa.
bank of the pond,
Hmm.
or bastu.
So why it is in residuary? It is a land
But-
matter then.
No, my lord, this is arising out of the decision passed by the High Power Committee. I have challenged the decision of the High Power Committee. That's why it is residuary. My lord,
I see. তো ওই অ্যাপিলটা সমেত এই অ্যাপিলটা নিয়ে লিস্ট করে দিও।
আপনি ওটা স্যার দিয়ে দিন।
What is can 1? Is your stay application.
in relation to this, can,
So writ petition was decided on affidavits.
No,
no, there is no,
Then do you intend to use any opposition?
there is no.
You don't know. So check it up, then we will hear it on a day whether
Yes,
it
my
is-
lord.
Petition was in fact the petition was disposed of with certain directions upon for investigation on the issue regarding the water body exists or not. That
আচ্ছা,
part of the direction was given, but it appears to be so, my lord, that
high power committee.
the High Power Committee, after that High Power Committee, the court also passes an order of, upon looking into everything. If you also looks at possibility that this order is under challenge,
Directing what?
directing the ascertain the status of the plot of land.
But how you are aggrieved by that, sir?
no, my lord.
There was a
The bank of the pond is a measuring, my lord, 0.9 decimal. Whereas my claim that 13848 plot is 6 decimal. Now, single judge, my lord, declared the entire 6 decimal is a bank of pond.
Now the high power committee has said that there has to be a fresh inquiry. That
That
is
is-
what Mr. Ghosh is saying.
That is Mr. Ghosh. My lord, that decision is erroneous. That's why I am.
এটাকে মানডে উইক রেখে দেবে ওই
My lord,
there is a direction upon the district collector as well as deputy director of fisheries to look into the report of the high power committee and conduct inquiry. That with that particular direction, the writ
So
petition
he
has
is-
been disposed of.
challenging the
So in
observation. of
another
the High
FMA,
Court.
my lord, in another matter, there is an application for condonation of delay. So, my lord, let this matter appear on a convenient date
Monday
to your
week, it
lordship.
will appear Monday week, both the
My lord, can it be on any other day, my lord, 7 except Monday, my lord, any day? My lord, because
Monday week.
my lord, Monday week, I presume there will be the monthly list, my lord, kindly.
No, no, 30th of
30th of June,
All right, keep it on Thursday, 3rd July.
my lord, grateful.
3rd July.
Grateful.
Mr. Ghosh also appearing. You are also-
My lord.
কি বলেছো? 30th জুনই তো।
My lord, the advocate on
তুমি
record.
ভুল বলতে পারো? আমি প্রায়শই তুমি কিছু যে personal ব্যাপার
My lord, the advocate on record, my lord, has suffered a family loss, my lord, due to which he has to rush to his native place, my lord. My lord, I'm praying for a fortnight, my lord, so that he can come back, uh, doing all the rites, my lord. After performing all the rites, my lord, I'm praying for a fortnight,
tell us when do you want it?
my lord.
2 weeks.
2 weeks, my lord.
The Thursday week করে দেবে। Thursday week it comes to
3 তারিখ।
3 তারিখে অনেক ঢুকে গেছে। Let it be on 9th July.
My lord.
Yes.
Much obliged.
Item number 6, this is my appeal, along with an application for leave to appeal. Lord.
I appear on behalf of the private respondent.
হ্যাঁ দাও।
Petitioner को service करो। Stated.
State rule. This is the way. Yes, repetition of the year. Okay. Leave to appeal.
Well, a writ petition was filed, well, in respect of my property.
You are opposing leave to appeal.
No,
You are not opposing.
But he was one
but
of the,
I was the owner. I have
Acha, acha, later.
handed over the
Yes,
property.
show us the order.
Okay.
No, tell us now what is the.
my lord, I tell your lordship, the property, initially the property belongs to my learned friend's client, which subsequently we got it. The
Learned friend is of respondent number.
No, here 6.
Here, it is-
Here
Writ
6.
petitioner.
no, he is not the
I'm
writ
the writ
petitioner. But I tell you, my lord, the writ petitioner was a tenant in respect of a particular shop room in the premises, which initially, now which I am the owner. There was a fire in the year 2012. And as because of the fire, the electricity company, the CSC Limited, they disconnected the supply. Since disconnection, he was not in possession. Thereafter, we and other owners, other tenants, we got connection by paying hefty penalties and also taking steps, fighting measures. 20s, as because the tenant was not paying any rent, a suit for eviction was filed against him in the year 2017. He tried to obtain electricity in the year 2020. There was a suit for restraining them to get electricity because he is not in possession and he is not paying any rent. And now he came up with this writ petition without implementing me. I am the owner, and he asks that there was resistance of electricity. It's not a simple case of registration of electricity. He is not in possession since 2012, not paying any rent to me.
It is Sarfaraz Alam.
The tenant is Sarfaraz Alam.
And another, who is the other one?
His wife.
His
His
wife.
wife. So
We have
she is-
served them.
Now, what had been the outcome of the suit?
Well, that suit, eviction suit is pending.
Eviction is suit is pending.
Pending.
Now,
He is not
in possession.
not in possession.
It is in whose occupation?
Well, it is lying under lock and key. That is the reason in my eviction suit. That is also one of the ground, non-payment of rent, and as because he is not using the suit premises, the
So you
shop
are
room.
the owner now.
Now I am the owner. I was not made a party.
Very good. Then what did the trial judge say?
Well,
What did the single
well,
judge?
he granted the electricity without going into these particular aspects of the matter. He says that yes, he is entitled to electricity. And all these entire things that was suppressed in the writ petition.
Now, who is appearing for him?
Malad,
He is not here before us.
no, writ petition is not before.
Then how can
Malad, we
hear?
have served them, my lord.
Hmm. Shamol, So, Mr. Shamol, you appeared for respondent number 4.
No, my
In
lord.
the writ petition,
Malad,
Original owner. I was appearing for the original owner.
you are Sarfaraz.
no.
Then who are you?
Mr. Reja was.
I was the original
Mr.
owner,
Reza was
but
appearing.
I was respondent number the 4 therein, and I have already handed over the property to
To him. Very good. You handed it over prior to the order passed by the court.
Yes.
So why
in
didn't you
2020.
tell the court? You didn't tell.
Yes,
Yes, he told my lord, your lordship kindly see
But
the
it has
order
been
passed by the
reflected also in the
honorable
order.
single judge. My lord, third paragraph, it is already, my lord,
Oh, it
said
is the
that,
son who is the new owner.
my lord.
Father had gifted the property to the
My
son.
Yes.
Oh, acha, acha. So, Sarfaraz হচ্ছে the writ petitioner. Sarfaraz and Shahida. তারাই এটা। Have you served them?
Yes, my
They have received. So what is the present status? Yes, you went and effected connection.
electricity was connection was given. Connection was given.
Pursuant to the order against which you have
My
come
lord,
up in.
after filing of this appeal, in the meantime, this connection was there. The CSC authorities have given connection.
He sees. You are CSC, na? State. CSC nahi. So, but now the order has been implemented.
My lord,
What
order has
appeal
been
do you want?
My lord, this order, my
Yeah,
lord,
the order must have said that this will not create any right title. Or
my lord,
interest.
it was not not
It was
reflected
not
in the
there.
order.
So we will modify only.
My lord,
the
that is, my lord.
into writ petition. Now it is still under lock and key.
Now still under lock and key.
How was it, how was the connection given if it was under lock and key?
My lord, it's a marketplace. He's a tenant in respect of a shop room. Your lordship kindly sees the impugned order, the order which has been assailed. There was a meter room. And there was, pursuant to the Honorable Single Judge's order, my lord, inspection was done. And it said that the meter would be installed in the meter room, which is earmarked for meters in respect of several occupants. And from there, electricity was given. But still now it's under lock and key. My lord, by this electric
How was connection affected if it was under lock and key?
my lord, connection was meter was given, meter was installed, and then from there supply would be my lord, later on. The shop room is under lock and key, the tenanted shop room.
Who was the respondent number 4 in the writ petition?
But I was the respondent number 4.
You were the
Yes.
respondent.
4 and 5, 5 already died in 2019. I made I was submitted before the Honorable Single Judge saying that they have unnecessarily made me a party because 2 reasons. One, respondent number 5 has already been died, and respondent number 4, I have already handed over to the property to my son.
No, the police was given liberty to break open the padlock of the meter room. That was not required to be done.
The meter room, that was not required to be done. Meter was installed. New meters were installed. They have installed meters.
Give us your affidavit of
Bit of service number I filed in it.
You have served the
My
leave to appeal.
My lord. Leave to appeal টা file করেছো, রিলিজ করেছো তো? আমি পেয়েছি তো। খুঁটি ডেলিভারিটা কাকে করা হয়েছে? Page 5 and 6 are service affected to the writ petitioners. Page 5 and 6. Sure.
Which advocate appear? Wasim.
Mr. Wasim Reza was appearing. We can inform him.
Then we simply adjourn it. You
My lord.
give a further information to Wasim Raja and come back to us.
Matter to appear on Monday.
No, next Thursday it
Next,
will appear.
yes.
You give a notice to the Mr. Reza, then they do not appear. We will
My
watch.
lord. An order may be passed to that effect, or
That's all. Also, affidavit of service, as filed, be kept on record in Item number 8.
My lord, since I raised several objections, private respondents were raising unauthorized construction, my lord. Due to that reason, my lord, I was threatened with dark consequences in collusion conspiracy.
We are not being able to hear.
My lord, when I raised objection upon private respondents number 8 and 9, my lord, don't to raise, and they, my lord, in collusion conspiracy with life convict who is confined in central Balurghat, my lord, wherein, my lord, I have been regularly threatened for dire consequences, my lord. Due to that reason, I filed a writ petition, but honorable single bench was pleased to observe that I did not take any steps in person of the in person of the messages from the Crya PS. But my lord, I was never sent any message. My lord, I was never sent any.
What is the order passed?
Lord,
Have you completed service? Have you completed?
I have served only state, my lord.
Sorry, that way.
So then, my lord, Lordship kindly grants, I shall serve all the respondents, my lord.
So now see, this matter was, I think, leave was granted, na? You obtained leave from us, na?
No, my lord, in the original side matter, my lord. In the original side matter.
So why haven't you completed service?
My lord, since I could not, my lord, due to my personal health, my lord, I shall.
Next Thursday.
Next Thursday.
I'm for the they are appealing, my lord.
I appear for the private respondents matter.
My lord, page 14 is the impeachment order in the stay application, my lord. Well, case in nutshell is that your lordship in the year 2013, my lord,
Who is your other side?
My lord, I am the
Well,
private
appealing-
respondent.
You are for the?
My lord, the private respondent. The petitioner in the writ petition, my lord?
You were the writ petitioner.
Yes, my lord.
I am the appellant and respondent. My lord, all the parties are appearing in this appeal also. If your lordship see the previous orders, my lord, they are appearing. They are appearing, your lordships.
WBACDCL.
Yes, my lord, they were also served with the copy. And my lord, they.
When it last appeared on 3rd March, you were not there.
Yes, your lordship. At that time, I was not.
The ACDCL, where is ACDCL? Have
My
you served
copy-
any notice
Yes, my
upon
lord.
them?
Notice, I might have not mentioned this matter. This matter automatically appeared before your lordship. I have not mentioned it again, your lordship. So, my initially notice was served, a copy was served upon them. It is, they have
So
reported.
you intimate them. It appeared on 3rd March when you were not there, but they were there. You private respondent is appearing.
Yes, my.
Give an intimation to this WBECDL advocate.
Yes, my lord, I shall give it. If your lordship directs me, I shall give it.
Come back on next Thursday. In the meantime, intimate him.
My lord, I'm grateful.
Yes.
But I am for the petitioner with Mr. Shataru Banerjee.
He's opposing you, Mr.
Mr. Siddiqui was not, he appeared on the last day, Mr. T.M. Siddiqui. He appeared on the last occasion.
Father was admitted,
About adjournment.
my lord, hospitalized for chemo, my lord.
Who?
His father is my lord cancer
Siddique?
patient.
Mr. Siddiqui's
My lord,
father.
my lord. My lord, they tumor yesterday my lord admitted, and my lord today my lord second chemo is my lord going.
When is he returning? He will
Today is completed, my lord. His Monday.
come next Thursday, Mr. Mukherjee. Come next Thursday.
I'll come. But may I just apprise your lordship about one fact? Because later on, after Lord, my deliberation, but in this matter, Lord, I purchased Lord this particular property, which is the subject matter of section 6(3) of the West Bengal Estates Acquisition Act, Lord, pursuant to the order of this honorable court in a liquidation proceeding. In the liquidation proceeding, Lord, before the company court, Justice Ranajit Kumar Mitra passed an order. That Lord, that has got nothing to do with this matter. But I should, Lord, at the first instance, Lord, apprise your lordship. It went up before the division bench. Division bench set aside the order of the sale of the single judge, went to the Supreme Court. Supreme Court restored the single judge's order, pursuant to which my client, the applicant before your lordship, has purchased the property from court's order. So this is the only thing that I say. It has got nothing to do with, Lord, the merits of the matter, wherein I challenge, Lord, the order of, Lord, the tribunal concerning non-mutation in favor of my client. And the government says that the property is not vested or should be not treated to be a property under section 6(3) of the West Bengal Estates Acquisition. That order has got nothing to do, but I should not apprise your lordship about that. ওটা তো সুপ্রিম কোর্ট থেকে তো সিঙ্গেল বেঞ্চ রেস্টোর্ড হয়ে গেল। না হিয়ারিং হবার পরে তারপরে যদি বলেন যে না এটা হয়নি, it has got nothing to do, but তাহলে
what order was passed by his lordship?
His lordship directed that my client should that was the highest bidder. My client will purchase not the property of Hindustan Pilkington Glassworks for 4.25 crores. Set aside by the division bench, Supreme Court restored the single bench's order,
So
setting
on
aside
the
the
basis
division.
of my lord's order, you have got the
I got the property long back. Lord, it was sold in favor of my client, Lord, by the official liquidator. And the question now is,
be a bit embarrassing for him, no?
but it has got nothing to do directly with this. But I say this because I'm not at the later stage. This is not a bit longish matter. After hearing, if your lordship says that you should have apprised us of this fact, then Lord, but I tell your lordship, it has got nothing to do with this. Because it is not at the time when I purchased the property, it was not the court sale order that was not the subject matter. WBA LRT Land Tribunal order থেকেই আসে।
You are challenging the order of the LRTT.
Of course, yes. That pertains to a different issue altogether. 6(3).
কিনে নিয়েছে যদি কেনার ব্যাপারটা তো ডিসপিউটেড।
That is not in dispute.
It's not at all a dispute, but only Lord because there is Lord. Because I apprise your lordship about.
Do you have any objection?
My lord, kindly, my lord, Monday, my lord, I have nothing to, my lord, in this brief, my lord.
Now, if he has that order of his lordship has already been implemented, he has purchased it, his sale is no longer in dispute. What is dispute is whether he would be mutated or not. That is the issue.
My lord, kindly, my lord, take it Monday, my lord.
In mutation, why mutation was refused, Mr.
Because they say that the government says that this property which was allocated to Hindustan Pilkington, the company in liquidation through which I have purchased, that was a lot of land which the government allocated to them by exercising powers under 6(3) of the Estates Acquisition Act. They say that because the factory work has not been resumed, therefore the government says.
So the sale may be called into question.
Sale was confirmed. So sale was confirmed. It was never challenged. So sale and all this, these are not the subject matter. Now the subject matter was the government says that you have not started production. I exercise my right under 6(3). I want to resume in respect of the 45 point some acres of land. That was the subject matter of challenge before the tribunal.
তোমার predecessor-এর ওই জিনিসটা যেটা চ্যালেঞ্জ করে mutation, এই প্রশ্নটা তো আসবে।
That is the point.
think we
The
keep
division bench was negated.
let him, whether any object, I don't think that there is any problem.
Monday, my lord, in presence of Mr. Siddiqui, my lord, I am not in brief in this matter, my lord.
No.
Acha, we keep it on next Thursday. You tell us whether Mr. Siddiqui, this fact that Mr. Mukherjee has pointed out.
Mal.
So we will take it up if it is on next Thursday, we will take it up.
Definitely. আমি তাহলে বলে দেবো কি বলেছে grateful.
What, you're not there? Mr. Banerjee is not there. Off to Bangalore.
I'm prompted by them that there should be a written order, my lord, for their part. That is the reason.
by my selection.
Grateful. Great.
Or I appear for the respondent writ petitioner.
Item number 12.
11 and 12.
11 and 12.
I appear, my lord, on behalf of the writ petitioner respondent, number 1. And in the item 12, my lord, I appear on behalf of the writ petitioner respondent, number 3. Against the same.
So, who are the appellants in the other appeal? Both are preferred by.
I'm telling you, my lord, short fact, my lord.
Why 2 appeals, Mr. Jana?
2 appeals. This is the, my lord, there is an award passed by the industrial tribunal. Challenging that award, I filed a writ petition. My learned friend filed a writ petition for implementation of that award.
Oh, achha.
So that's why 2 appeal is there. 816 টা দিন
Our writ petition was first filed for implementation of the award. When it was pending, then long thereafter, they filed the writ petition challenging the award.
816
Now, the second writ petition, how it was disposed of? Implementation?
No, my lord, both are
First writ petition for implementation ours.
Very good. Now, what? Achha, show us the.
Both the writ petition are disposed of by a common judgment.
Not extensive. So you have concluded your arguments. Mr.
Yeah.
Dotto appeared. No?
Now, Dotto is leading me, my lord.
No, it appeared before us on March, 13th March, when we heard Mr. Dotto.
Yes.
Yes.
You just point out.
What I am
point out. Therefore, let us hear that submission. In reply,
Yes.
then Mr. Dotto, if required.
Very well.
Huh? I will-
The petitioners here in my lord.
Or Mr. Jena, you want to Mr. Dotto's assistance you require.
I cannot pray for every time, my lord. Whatever my capability, I can make my submission. Obviously, এই বয়সে তো লজ্জা হয়।
Oh, acha. Yes, Mr. Jena.
I'm giving you short facts of the case, my lord. If Mr. Dotto, he make. But these petitioners, workmen, I'm saying the workmen, my lord, the writ petitioner filed by my lord. They were the temporary workmen. They were not engaged against any substantial post. Maybe they were all from the employment exchange. Not against any substantial post, they were the temporary work.
So this engagement is admitted.
Contractual, yes. Contractual engagement. They prayed for absorption. Those workmen. Absorption.
How many people were there?
Initially 61, now it is around 50, 42.
Yes.
The matter referred to Industrial Tribunal, my lord. The reference is, your lordship kindly see at page 82 or 26, whatever may be. 26.
Mr. Jena, you are placing which file?
816. Pat.
816.
816. I mean 816 আমি ready আছি।
You are placing 816.
816.
তাহলে 816 এর
816 এই তো দিতে বললাম। আপনি 816 টাকা মার্ক থাকবে।
Item number 11 is my lord 815. MAT number 815.
No, he has prepared himself from 816.
সবকিছুতে objection.
ঠিক আছে, no objection.
Then he
Just
can
telling.
point out the page numbers. When we
Judgment is one covering two matters. We also take trouble to read the judgment exhaustive judgment. Everything is.
So that is there. I will come later on, my lord. What is the judgment from threshold? I will tell.
Page 80.
Kindly 82. That is dated 23rd May 2006.
জয়ন্ত শোনো, তুমি ছাড়ো।
No.
Yes.
Now, therefore, in exercise power conferred on clause D, subsection 1 and subsection 2A, section 10, Industrial Dispute Act 1947, the central government hereby refer the dispute for adjudication to Central Government Industrial Tribunal, so and so, the schedule. This is the reference schedule. Whether the action of the management Kolkata Port Trust, Kolkata, in non-regularization service of 61 workmen, as per list attached, engaged on temporary basis, on permanent basis, as mentioned against the name in the list, is legal and justified. If not, what relief they are entitled to. So here is, my lord, the reference.
Whether they were engaged on.
There will be regularized or not. Only the reference is this. They are appointed on temporary basis, whether they will be regularized or not.
No, on the basis, on the permanent posts as mentioned against each name in the list.
The management or non-regularization of the workman engaged in temporary basis on a permanent as mentioned in the each name list legal offense. This is the reference. So my contention is first, the reference is only to the extent for regularization. Either they are temporary or permanent, that will, my lord, I will make submission, that aspect. First of all, the reference is only with regard to regularization. The central government can modify, central government can, by making a corrigendum, change the reference, but court or any other authority cannot change the reference.
Yes.
This is the reference. Now, your lordship, kindly short facts. In my petition, your lordship, kindly only 3 or 4 paragraphs. Kindly see. 5 to 8 only. Lordship, kindly see the paragraph 5 to 8. Page 4 of my petition. Because the reference I have showed to you and the small facts I have stated in paragraph 5 to 8. The petitioner states that in 1995, around 1,150 dining analyst candidates were called for physical tests for recruitment in different departments in Group 4 post. Following the test, a select list of 350 was prepared. Out of those 350 candidates, 264 were employed against various permanent posts in Group 4 grade. The balance 86 candidates were then chosen for the Marine Department as a temporary worker on 41 days put up to work against leave vacancies. The marine department, there are various vessels. As and when one vessel has come, they walk there.
So they were all, initially, they were all seeking compassionate appointment.
No, they subsequently, thereafter, temporary. Then, however, many permanent posts were abolished due to condemnation of the vessel beyond the work temporary as to have.
No, Mr. Jena, paragraph 5, first line.
Yes.
Petitioner says in
Died in
95, about 1,150 died in harness candidates were called. So this 86 is also a died in harness candidate. Yes.
Next 6. The petitioner states that subsequently 42 of those candidates were absorbed in various sanction class 4 posts in the marine department, leaving 42 candidates. Leaving 42 candidates. Out of the 42, 5 have now expired. So 42 minus 5, now remaining 39.
No, 44.
44, 5 has died. So now 39.
So these 5 were absorbed, or they were
these are
the persons who expire?
No, they have not.
So they come within their group.
Yes.
So 5 expired.
Yes.
Their names have been expunged from the records.
No.
They are still there.
They are still there. No substitution or expunge or nothing has been done.
Yes.
The petitioner said that another 52 candidates applied group 4 post sponsored by local employment exchange. This is died in candidate, 39 remaining after expire. Now, another 52 candidates applied for group 4 post sponsored by local employment exchange. Out of lot of 52 candidates, 35 were absorbed. So 52 minus 35, the 15 were remain. Against post 17 candidates, out of which they have died. There are 14 candidates put in this lot who worked as a temporary workers. Your petitioner
So
said
39 plus 14.
Yes.
That comes to 40. 50,
Presently 50.
53.
Paragraph 8, your lordship can see paragraph 8.
Yes.
That has been clarified. Your petitioner said that presently there are 50 temporary workers, 36 in died-in candidates, and 14 sponsored from the local employment exchange. So your lordship can clarify, it's clear, some died-in handlers and some local employment exchange.
No, but how it becomes 50? It is 39 plus 13. 39
maybe
plus
1 or 2 or some has expired. Some.
আচ্ছা ঠিক না ওদের মধ্যে 50
Here, my lord, my contention.
39 লিখলাম 36 হয়ে গেল
36 13
39 44 minus 5
44 minus 39
এখানে 36 টা হলো কি করে?
In paragraph 6 you said that out of 44 5 died.
Yes.
So then it comes to 39.
39.
Then in paragraph 8 you are saying 36.
No. 50. Presently there are 50 temporary workers, 36 in died-in and category.
গল্পটা কি?
Now the paragraph 8 is the relevant. Paragraph 8 is the relevant. So
Paragraph 8 says
50 temporary workers, 36 died-in candidates.
No, my brother is asking in paragraph 6 you said 44.
Paragraph 6,
44 in respect of marine department were remaining.
Yes.
Out of them 5
9, 39. It should be 39. It
so
should
in
be 39.
paragraph
Correct.
8 it should be 39.
39. Correct, man. Correct.
Then it's not 50, it will be 53.
So maybe I'm taking mathematically some may be wrong. The issue has to be decided, one or two. That is a different issue. So none of these 50 candidates are working against any sanction post but on temporary. This was my first submission before lordship. None of those 50 candidates are working against any sanction post but on temporary vacancies. Page 4 of the petition.
Yes.
The petitioner said that in the aforesaid background, since these workers were seeking regularization by notification dated such and a corresponding suggestion of the government of ministry so and so under section 2 so and following. This is the reference I have showed to your lordship. This is the fact and this is the reference up to. Now your lordship kindly.
No, the reference does not.
Please, whatever, let me finish.
Leave me.
Oh, acha, tal.
Yes.
You're hearing me here.
Mr. Jena, this notification was not referred to in the reference.
No, reference is there. Thereafter, reference was issued. That reference. Reference was issued that I showed to you.
So your argument is their case was.
I'm coming. Coming, my lord, coming. This is the factual aspect of the matter, and this is the reference to the CIG. And what was the contention before the tribunal by the workman? Kindly see their plaint.
Page
86. My lord,
in non-regularized.
I will not trouble to your lordship entire plaint, my lord.
Please don't temporary.
Here, my lord.
Who's as mentioned against each name in the list in this step. Mr. Jena, just page 82, the reference. Please come back to the reference.
This is also quoted in the impugned order.
No, right.
Yes,
What is this? In the third line, it is said on the permanent post as mentioned against each name in the list. Which is this list?
List is annexed here. List is annexed here. List is there, my lord. In the list, my lord, I will also see page 92. In the plaint, they have mentioned list. Page 90, 91. 91 onwards. 61, yes, 91, 92.
The permanent ultimately দিতে পেরেছিল 42 Yes, page 86. You are referring to page
86, their application or plaint, whatever before the time. Well, I will not trouble your lordship the entire plaint. I am telling you, lordship, in this plaint, nowhere they are said about the unfair labor practice. They are asking for regularization. Nowhere in the plaint, or it is not the case of the workman due to unfair labor practice. They are not paying our remuneration or wages, whatever may be. On the contrary, they ask for regularization
in temporary post.
Temporary post. That is my comment. They are saying temporary post, no against no substantive post. Now, your lordship, come to the impugned order. Judgmental.
সিনিয়র কি বলছে from সিনিয়র বলছে ওই প্যারাগ্রাফ দেখাও
Now you kindly see lordship page 140 of the award. 140. Award. But in the proceeding, my lord, I have filed an objection. Evidence is there. Everything is there. That has been also referred to the judgment. That I will later on. I will see all this. So the award passed. Your lordship can see the award. Now, Mr. Nit. Yeah. And leave me.
Yes, take.
My lord, in the award, what is very important is আচ্ছা পেজ নাম্বারটা আমাকে একটু বলে দিস Your lordships had the award open.
Page 86.
Yes.
Yes.
Now, my lord, the first paragraph of the award is very important for us. By the order number so and corrigendum number so, the
When you are
government,
reading, Mr.
my lord, the award first paragraph.
Award is in
140. 140.
Yes. Yes, Mr. Dutta.
Yes, ma'am. The first paragraph, by order number so and corrigendum number so, the government of India, in exercise of its powers under section 10, referred the following dispute to the tribunal for adjudication, where the reference is whether the action of the management of the Kolkata Port Trust in not regularizing the services of 61 workmen as per list attached, engaged on temporary basis on the permanent posts as mentioned against each name in the list is legal and justified, if not, to what relief they are entitled to.
Yes.
Now, my lord, paraphrasing the reference, where what is of most important is the persons or the workmen, they were claiming to have been engaged on temporary basis on permanent posts. This is very, very important for this case. Temporary basis on permanent post. Mr. Jena has, my lord, addressed your lordships or apprised your lordship that there were no permanent posts. But the reference is that these persons were working on temporary basis in permanent posts and were claiming regularization. But on this, the tribunal holds in favor of the establishment that they were not working against permanent posts. So, this reference part is of immense importance, that persons who were allegedly engaged on temporary basis in permanent posts, whether they should be regularized or not.
Yes. Yes.
Now, my lord, if your lordships may kindly, my lord, permit me to place a few paragraphs, and then, my lord, I'll take your lordship through the judgment under appeal. But then, my lord, is the list of the members or the persons. Then notices were issued. My lord, your lordships may kindly take internal page 4 of the award. Internal page 4 ta kota কথা বলতো একটু?
Para 3.
Yes, para 3.
That is their written statement. Your written statement.
It is, my lord, my stand before the tribunal. Management of Kolkata Port Trust filed its written statement stating that the Kolkata Port Trust has a number of departments under the Kolkata dock system and one department is the marine department. In order to facilitate activities, it has become necessary for the marine department to engage persons against leave vacancy. At a very short time initially, these persons were engaged from outside, sponsored through employment exchange. However, such practice was objected to by the union, and it was claimed by the union that men who worked in the past should be preferred against the short-term vacancy. Therefore, ex-employees list was accordingly drawn up with the persons who had worked in the marine department in the post and who had been sponsored by the employment exchange. In the year 1972, separate departmental and sectional lists were prepared of persons who has been engaged against casual vacancies. From these lists, not only short-term engagement but also regular appointments were made. After absorption of most of the ex-employees of the list of 1972, similar lists were again drawn up in second time in 1982. In 1985, a committee was constituted for the purpose of enlisting ex-employees. The committee enlisted 66 candidates for the post of Lashkars, 25 candidates for the post of Bhandaris, and 12 candidates for the post of Moshalchi, and 5 candidates for the post of Topaz. Along with enlistment of ex-employees, it was also decided to fill up temporary posts of Bhandari, Topaz, and Moshalchi in dyed and harness category, subject to fulfillment of certain criteria. In course of time, a pool was also formed by the dyed and harness candidates for engagement against short-term vacancy and also a adjustment against permanent vacancies. The Kolkata Port Trust, having a large number of workforce in different departments, sometimes it was experienced that in one department a number of employees remained idle for want of adequate job, whereas in other department there were shortage in operational areas. Therefore, identifying such idle workforce, 29 permanent employees were adjusted against various operational posts in the marine department. The action of the management was disputed by the union, and an industrial dispute was raised by the union demanding confirmation of 61 persons who were engaged for specified period and on completion of the said period were put off duty under the provisions of so-and-so regulations. It is further submitted that out of 61 persons under reference, 1 person is missing. Therefore, the schedule of reference as framed is not maintainable. It is also submitted by the management that the cause of 61 persons has not been properly sponsored by the union. Therefore, the reference is also not maintainable. The management has also pleaded that in the marine department, posts have been filled up on regular basis from time to time as per operational requirement from various sources, that is listed employees, listed dyed and harness candidates, listed trade apprentices, and surplus personnel. Prior to regularization of the listed ex-employees and the listed dyed and harness candidates, they were given contractual employment against short-term vacancies, and during such engagement, they were paid DNS allowance in addition to pay consolidated overtime allowance as per award of tribunal in reference number, etc. The allegations of the union regarding posting of 12 employees in the medical department and their subsequent transfer to marine department are not only baseless but malicious. The contractual engagement listed of listed ex-employees and dyed in harness candidates are distinctly different from the term appointment as per regulation 6 of the regulation. As per regulation of 1985, an employee is eligible for confirmation only against permanent post on completion of the prescribed period of probation, and since none of the concerned employees has been appointed against permanent post, demand of their confirmation does not merit. Therefore, my lord, the stand was very specific that, my lord, here they were not appointed, my lord, against permanent posts. Now, my lord, we need to, my lord, address your lordship, my lord, then what is the stand of or what is the finding of the tribunal? Acha, on this aspect. My lord, your lordship may kindly take me to the next paragraph. The union, well, the next paragraph. The union filed its rejoinder pleading therein that the term ex-employees is vague and incorrect. Actually, these ex-employees were appointed against permanent vacancies and did the same work that the other permanent employees did. But the management of Kolkata Port Trust, adopting their unfair labor practice, kept them temporary till now. The management of the Kolkata Port Trust invented a unique system of giving them 1 day off after completion of 41 days of service, only to create an artificial break in service so that these employees remain deprived forever for having the status and privileges of the permanent employees. Therefore, my lord, this was the two contesting stand of the two parties or the three parties. Workers say that they were on permanent appointed against permanent post. Union also says so, but my lord, the employer, that is the Kolkata Port Trust, says that no, they were not appointed against permanent posts or permanent vacancies. Now, what is the finding of the tribunal on this? Yes, paragraph 8 also, my lord, your lordships may kindly have a look. According to the management, the nature of employment of the workmen under reference is contractual. They are not working against any permanent post. Hence, they are not entitled to be regularized. The management has also at the very outset taken objections to the maintainability of the reference on the ground that out of 61 workmen under reference, so and so is missing. Your lordship may skip over that. Therefore, my lord, the consistent stand was that they were not appointed against permanent posts. Now, my lord, your lordships may kindly have a look to what is the finding of the tribunal on the aspect of whether they were appointed against permanent posts or not. My lord, without wasting your lordship's time, my lord, internet page ball, ওই ফাইন্ডিংটা যেখানে দিয়েছি। প্যারাগ্রাফটা গেল কোথায়? ইন্টারনাল পেজটা বল। Yes. Well, internal page 15, paragraph 23.
Yes.
Relying on the above decision of the Constitution Bench of the Honorable Apex Court, the management of Kolkata Port Trust has contended that the appointment of the workmen under reference was contractual nature, which expired with the period of contract. Though the added union has denied that services of the workmen under reference were of contractual nature, but the union itself has filed appointment letters of some workmen, say Ashok Kumar Shil, Shapon Kumar Das, Radha Charan Sarkar, in which it has been specifically mentioned that the engagement was contractual for specific period mentioned in the letter. These letters were issued to the concerned workmen for a specified period of period in short-term vacancy. But it is not denied, rather admitted by the management that 53 workmen under reference are still working with the Port Trust. The authorized representative of the management has failed to explain as to how these workmen are continuing in their job if the contractual period has expired, if the contractual period have expired. However, there is nothing on record to show that the workmen concerned were appointed against substantive vacancy. Specific finding. Hence, the ratio of Secretary versus Secretary State of Karnataka versus Uma Devi Supra is fully applicable in this case. Well, it is fully applicable. Possibly the word not is missing, but I will not, my lord, make any submissions on that. According to me, my lord, the word is missing. Anyway, my lord, the tribunal comes to the finding that these persons were not appointed against substantive vacancies. Reference is that some persons who claim that they were appointed on temporary basis against permanent posts, whether they are entitled to regularization. The Potra stand is that no, they were not appointed against permanent vacancies. The tribunal, my lord, at paragraph 23 comes to the conclusion that no, they were not appointed against any substantive vacancy. Therefore, my lord, in my very respectful submission, my lord, the reference being on such terms, and after, my lord, paragraph 23 of the award, my lord, the tribunal could not have decided anything further. Now what the tribunal does is, the tribunal, my lord, takes the route of unfair labor practice. My lord, Mr. Jinnah had said that the reference did not contain
Unfair labor practice.
unfair labor practice. But I'll address your lordship on that aspect, that whether the reference can be expanded by the tribunal at a later point of time.
Yes.
But the tribunal returns a finding that the employer is making them work for a certain period, then giving a 1 day artificial gap, and then again re-employing them. Now this is unfair labor practice.
Paragraph 8.
Yes,
Understand.
yes.
But unfair labor practice do not feature in the reference.
Reference. This is the most important point. Now please take, my lord, para 26. Apart from this, the Honorable Apex Court has also reiterated its earlier judgment in so in Civil Appeal so in which the Honorable Court has held that the provisions of the Industrial Disputes Act and the so not under consideration in Uma Devi's case, such and such practice was neither the subject matter of decision nor was it decided. The Industrial Disputes Act made for settlement of industrial dispute prohibits unfair labor practice on the part of the employer in engaging employees as casual or temporary employees for a long period without giving them the status and privileges of the permanent employees. The Honorable Court also held that it is always open to the employer to issue an order of retrenchment on the ground that the initial engagement of the employees was not in conformity with Article 14 and 15 of the Constitution, conferment of permanent status, the employer can pass an order of retrenchment of the employees in accordance with the provisions of Section 25F. Thus, where there is unfair labor practice on the part of the employer in continuing the casual workers for a long period without making them permanent so is not applicable to the tribunal. In the instant case, it is not disputed that the concerned workmen are but I'm sorry, Miller. In the instant case, it is not disputed that the concerned workmen are working with the management since 1989. The fact is also admitted by the management witness, so and so, the union's witness, so and so, has deposed that they have been shown put off on each and every 41 days, but in reality, they have not been put off their duty. They have further stated that as and when they were on vessel, specifically down the river, they had to work continuously without any break of service. In attendance register, 1 day was put off after every 41 days. Work is also admitted by the management in so and so. See, Prabhat Chattopadhyay in his cross-examination, where he has deposed that the said employees are said to be contractual workers as they were given 1 day's break after a spell of 41 days work, and their remuneration are calculated on the basis of number of days work performed by them. Thus, break of 1 day artificial put off is also reflected from the statement of the management witnesses. Thus, break in service by the management is claimed to be unfair practice by the added union. The unfair labor practice has been defined, etc. In the instant case, para 28, it is admitted between the parties that the concerned workmen are working with the Kolkata Port Trust since 1989. Though the management has branded this workmen as contractual workmen, but management has failed to show as to how, even after expiry of the terms of the contract, these workmen continue to work. Contrary to the case of the added union is that the management has deliberately continued the workmen under reference as bodlis or casual workers with the object of depriving them from the status of permanent employees. The evidence available on record is sufficient to show that the workmen has been kept as casual workers and they have been forced to take off one day after service of every 41 days. This is nothing but unfair labor practice on the part of the management. It is not out of place to mention that out of 61 workmen, 8 workmen are not working in the port trust at present. These names have been disclosed by so-and-so in his chief, but the added union has not cross-examined. The only question which has been asked to the witness is whether the employees worked continuously for 17 months. Hence, the statement of the witnesses, which is not challenged by the added union, shall be taken to be admitted. Therefore, persons who are not presently working with the Kolkata Port Trust can in no way be absorbed in service. Only those workmen are entitled for the absorption who are presently working with the Kolkata Port Trust. Further, it is held in so-and-so's that regularization cannot be directed from backdate as it will disturb the seniority or of regularly appointed employees in the cadre. Hence, the workmen are entitled for regularization with effect from the date of publication of this award. In view of the continuance of the workmen concerned with breaks as casual workers for a period of 30 years from now certainly amounts to unfair labor practice. So, therefore, social justice demands that the order of absorption of the workmen concerned may be passed, directing the management to absorb these workmen under reference who are still working with the Kolkata Port Trust. Now, my lord, two aspects over here. Number one is that the tribunal adopts the unfair labor practice route, which according to me could not have been done because of the limited scope of the reference. And number three is assuming that the tribunal could have adopted the unfair labor practice issue. Milord, please take the last line of para 33, 30. Please take the last sentence of para 30. Hence, the workmen would be entitled for regularization with effect from the date of the publication of this award. That is from 1st of August 2019. May the learned single judge has changed this also. However, these are the fundamentals, Millard, on which Millard, the case is required to be decided, or this appeal is required to be decided.
Yes, Mr. Do.
Now, my lord, two writ petitions were filed. One, my lord, by my client, that is the employer, Port Trust, challenging the award.
Yes.
The other writ petition was filed by the management
For implementation.
for implementation of the award.
Yes.
Workers, I'm sorry. And other position. Other position. But the other writ petition was filed by the union, my lord, for implementation of the award. এবার অ্যাওয়ার্ডটা কোন কথা আছে বল? এই ডিভিশন বেঞ্চের অর্ডারটা, এই সিঙ্গেল বেঞ্চের অর্ডারটা 25. 20. But at page 24, my lord, your lordships will find, my lord, I'm sorry, my lord, I'm sorry, my lord.
হ্যাঁ, ঠিক আছে।
Page 23 is, my lord, the order of the learned single judge.
Yes.
My lord, maybe very, very, my lord, technical, but my lord, the first line, sentence of the award, my lord, is on a wrong premise. The two writ petitions have been filed challenging the award. Dated so and so, passed by so and so. Now, my lord, facts of the case, I don't think, my lord, I should trouble your lordship any further, because we have given, my lord, our facts. But that paragraph,
Yes, Mr.
kindly comes to, my lord, paragraph 11. Internal page 4. But here, my lord, the reference is quoted.
Earlier occasion you placed para 14.
I'm sorry, my lord.
Earlier when it was being had, you showed us para 14 also.
Yes. Oh, it's marked then.
Yes.
Now, kindly take me para 14 minute, as your lordship was pleased to, my lord, indicate. After discussing the evidence that came on record and referring to the arguments of the party, the tribunal found that the workmen were engaged contractually for the specific period mentioned therein. The tribunal found nothing on record to show that the workmen concerned were appointed against substantive vacancies. These are on record, my lord. I'll not trouble your lordship. Then, my lord, Uma Devi is ever the tribunal found that the decision of the Supreme Court in so and so would be a bar against regularization. Accepted. Now, kindly take para 16. The tribunal answered the first part of the reference, that is, as to whether the action of the management of the Kolkata Port Trust in non-regularizing the services of the 61 workmen engaged on temporary basis on permanent posts in the negative against the workmen. Now, kindly take, my lord, para 17. The tribunal, however, thereafter went on to decide whether the Port Trust engaged in any unfair labor practice to address the part of the reference as to what relief they are entitled to.
Yes.
But coming back to the reference once more, Miller. It's at paragraph 11 of the judgment.
Yes.
The last part of the reference, if not, to what relief they are entitled to. So we are, my lord, on if not to what relief they are entitled to. But whether, my lord, unfair labor practice can come within that or not. Then, my lord, his lordship, my lord, না, 17 তো দেখানো হয়ে গেল। But dear lordships, may skip over, my lord, paragraph 18, 19, 20 for the time being. Then, my lord, submissions of the port trust in paragraphs 21, 22, 23, 24, 25, 26, 27. Workmen submissions are thereafter noted. Now, please come to, my lord, para 31.
Yes.
Having carefully heard the counsels for the parties, the arguments of the port trust based on the decisions need to be addressed first. The dicta of Umadevi 3 is primarily against the High Courts and the Supreme Courts directing permanent absorption of irregularly and illegally engaged casual daily wage and contractual employees. The said decision does not deprive the High Court and the Supreme Court and the tribunals of the power to direct absorption of legally and regularly engaged employees, and in the case of unfair labor practices adopted by the employer. In Umadevi 3, my lord, I skip over, my lord, the quoted portions. 32, your lordships may skip over. 33 also, my lords may skip over. 34, 35, 36, 37. Then please take 40. Internal page 14. This court finds that the workmen before the tribunal comprised in two categories. The persons under the first category were part of the recruitment process in the dyed in harness compassionate employment category, where 350 candidates participated in a regular selection process. 264 candidates were thereafter employed and appointed against permanently sanctioned posts. The remaining 86 were appointed temporarily against permanently sanctioned posts. Such vacancies arose due to leave taken by the regular employees or because some had resigned and left. 42 out of 86 employees were permanently absorbed in sanctioned posts and 39 remained. Admittedly, as per the letter of the chairman dated 21st December, that was exhibited before the tribunal, there were 107 vacancies in the marine department, despite whereof 39 out of 44 workers, 5 had died, were not absorbed permanently. In the second round of regular recruitment process, where 52 candidates were sponsored by the exchange, upon being invited by the port trust itself, 35 employees were absorbed permanently against sanctioned posts, and 17 were engaged temporarily also against sanctioned posts. 4 of such employees had died. It therefore cannot be said that there was no valid process of recruitment or engagement of the petitioners or that they were contractual. No such contract has been produced by the port trust before the tribunal. The persons who were considered for recruitment in the two stages referred to above have been absorbed against permanent vacancies. Both these stages were normal and regular recruitment process. The remaining persons, being the workmen, were admittedly engaged in permanent post, albeit temporarily. They remained temporary for decades despite vacancies in permanent post. Each one of the 61 workmen was deliberately and willfully engaged temporarily against permanently sanctioned posts. The process of recruitment did not have any illegality at all. If there is anything that is found illegal, it is temporary engagement of the petitioners and characterizing them as contractual, whereas a majority of those who were engaged along with the petitioners were given permanent employment in sanctioned posts. It further appears from the evidence on record that the workmen were paid bonus till 2007 all the way from the year 1995. They were given helmets, etc., etc. They also got promotions. Most of the workmen were provided with and stayed in the port trust quarters. All of them were provided casual medical and annual leaves. They were also given bonus from time to time. they obtained treatment at medical facilities of the port trust. The workmen were therefore treated at par with the permanent employees and yet deprived of the monetary and other benefits being paid to permanent employees. Shama Prasad Bose, the management witness, has admitted in his deposition before the tribunal that the workmen were all engaged in permanent posts and despite repeated requests, their services have not been regularized. He has further deposed that the jobs performed by the workmen were perennial in nature. Prabhat Kumar Chattopadhyay, the other port trust witness, has deposed before the tribunal that the 61 workmen are being provided quarters and are getting basic DA, HRA, and CCA. He has also admitted that the workmen are performing the same work as that of the permanent employees. Both the management witness has confirmed that the chairman of the port trust has approached the ministry for permanent absorption of the 61 workmen by the letter of so-and-so. In the backdrop of the oral evidence of the management in the examination in chief, as also in cross-examination, the documentary evidence, the argument of the port trust that the petitioners are working in permanent posts, are not working in permanent posts, must be rejected. Pausing here for a moment, Milord. This is, Milord, my first ground of attack or challenge, that when in the award the tribunal held that they were not appointed against substantive vacancies and there being no challenge by the workmen or the union to that finding, the learned single judge Miller could not have returned this finding at paragraph 47 of the order.
Must be rejected. Contractual কথাটা বলা আছে ঠিক নাই
এটা contrary to
Last তিনটে It's nothing on record to show the court will be appointed. না আমি পড়ে আমি বললো that is such Yes.
Now, this finding at paragraph 47 is possibly because of the finding at paragraph 42, the last sentence. Please take Miller the last sentence.
42 last sentence.
No such contract has been produced by the port trust before the tribunal.
Now see page 154, page 2, paragraph 23.
Yes. But please compare this last sentence with page 154.
Paragraph
That is
8, last 3 lines.
Yes. Para 23 last 3 lines. ঠিক আছে.
So that was reversed.
That was reversed.
Then what is your argument to that? That reversal?
Millard, first is Millard, this would be.
They were not in permanent post. So
they were not in permanent post.
So what is the court's finding for reversing such finding? That
Millard,
is only
for
because
reversing such
contract was not-
finding, according to me, Millard, the only finding which I can correlate is para 42. which I can correlate subject to correction by Mr. Banerjee.
Yes.
Then, Milord, if I may read further. So, Milord, the first is, Milord, the Honorable Single Judge alters a finding of the tribunal which was not challenged based on another finding which is contrary to evidence.
Yes.
But I don't want to reiterate, Milord, the entire award was unchallenged by the workmen. Insofar as the tribunal embarking upon the inquiry as to whether Port Trust is guilty of unfair labor practice in treating the petitioners as temporary, casual, and bodily for 30 long years amount to unfair labor practice is concerned, this court is of the clear view that the tribunal has not travelled outside the scope of reference. Para 54 minute with respect was not argued. Rule 20D of the West Bengal Industrial Disputes Rules is as follows. Milord, West Bengal rules does not apply. We are before the central government tribunal.
Yes.
Milord, on the issue that was argued as to whether the tribunal could have expanded the reference by the court, Milord, there was no contrary argument. Let us not go into all those disputes. But what is sought to be applied over here is a rule which is not applicable, or the entire West Bengal rules is not applicable, because this is a central government industrial tribunal. Where the rules pertaining to the central government administrative tribunal do not permit, in express or implied terms, to expand the reference. Now, what does Rule 20 say? Rule 20 says, 20D, addition of issues or parties to the proceeding. After parties have filed their statements, the industrial tribunal may fix a date for framing, if necessary, issues relating to and arising out of the point or points in dispute as referred, and matters incidental thereto, as well as additional or subsidiary issues not enlarging in any way the scope of the points referred for adjudication on the merits, or adding to their number, but requiring for dealing with extrinsic contentions raised by the parties about the terms of reference for its hearing. But my first submission would be, Milord, Rule 20D of the West Bengal rules does not apply. Now, assuming for argument's sake that it applies, then also, Milord, the procedure has been mentioned.
What is the procedure?
Procedure is the court, labor court, will fix a date for framing the issues.
Oh, achha, yes.
Then not any issue, issues relating to and arising out of the point or points in dispute, as referred, and matters incidental thereto, as well as additional or subsidiary issues, not enlarging in any way the scope of the points. Mhm. Or the third objection is, assuming the rule applies, the rule.
No additional issue framed.
No.
The rule applies.
No issue, no additional issue.
No, that is what you are arguing, no?
No.
Even if it is followed,
yes.
Then what is your argument that
first is
it was not in consonance with the rule itself?
Yes, procedure was not in consonance with the rule also. And third is, the rule also debars enlargement. Please have a relook to 20D.
Not enlarging.
Not enlarging.
Yes. Yes, please.
So, my lord, no issues were framed. And rightly so, because the tribunal, Central Administrative Tribunal, was aware of its powers and restrictions. Yeah.
Yes.
Now, my lord, please take note, paragraph 55. It is clear and evident from the aforesaid rule that the tribunal can frame additional issues based on extrinsic condition raised by the parties. Such extrinsic and external issues are vitally necessary for addressing the reference in the case of State of Madras versus so and so. Then, my lord, your lordships may kindly take para 56. Indeed, to expect the appropriate government to identify and specify the exact nature of the dispute at the time of reference in all cases is neither feasible nor practical. The tribunal must therefore be understood to have the power to frame additional issues that arise out of the facts on record and vitally related to the subject matter of reference. The expression extrinsic contentions under Rule 20D above must be understood as those claims and rights and liabilities which automatically or consequently arise out of the basic subject matter of the reference and the facts intrinsic thereto. But I will address your lordship, my lord, on para 56 later on, that to add to a reference where the matter must go back to the government.
Yes.
Then, my lord, your lordship may skip over para 57. Please take para 58. It is therefore held that the tribunal did not commit any illegality and has acted within the scope of Rule 24, 20D and 24 of the West Bengal Industrial Disputes Rule. On the application of Clause 10 of Schedule 5 of the Industrial Disputes Act, the tribunal has rightly found that insofar as artificial breaks of 1 day after 41 days of continuous engagement, the port trust was guilty of unfair labor practice. Reference in regard is so and so. Hence, para 61. Hence, in addition to the answer in favor of the workmen, as found by this court with respect to the first part of the reference, this court is also in concurrence with the finding of the tribunal that the port trust has also engaged in unfair labor practice. Conclusion: for the reasons stated herein above, all the 61 persons shall be entitled to permanent absorption from the date of reference. But I cannot be worse off by challenging an award. But the award says that they are entitled from the date of the award. The learned single judge has given the benefit, my lord, from a retrospective date. Those who have, kindly see the next sentence, further addition, those who have retired or have died during the pendency of these proceedings would be entitled to all benefits available to them as permanent employees with effect from 4th July. The tribunal did not extend the benefits, right or wrong, to those who were not surviving. Then para 63. The workmen would be entitled to all arrears of salary as permanent employees, including any terminal or retirement benefits like pension and provident fund. In other words, they shall be given all the other benefits available to permanent employees, monetary and non-monetary, with effect from 4th July 2006. Insofar as employees who have died, their families shall not only be entitled to areas of pay and allowances of all benefits, but also family pension payable to permanent employees of so and so. So, but this is again, my lord, going, my lord, beyond, my lord, the award that was passed.
Yes.
My lord, would your lordship, my lord, give me an indulgence? I have a matter fixed at 12:45. Could I stop here today, my lord? But I have to place only a few judgments, then it's over.
You give us a date. We'll finish it. Because we will again forget.
No. Next week. Sometimes next week.
সোমবার পরে ঝামেলা না
বলে
এটা ভুলে যাবে শেষ করে
না হ্যাঁ আমিও তো বলি
এই কার্তিক একটা দেখে নেব কি বলে।
বলবার দুটো
এই
Mr. Banerjee also consult. How
Why not?
long will you take, Mr. Banerjee?
He has not yet finished.
He will take. He will now place the judge.
judgments.
My lord, I'll not take much.
Maximum.
Mr. Banerjee, please agree to a date because if it.
I'm grateful. After all, I've been able to catch Mr. Advocate General.
We will.
Even today, he said,
has never agreed with me in on anything.
No. He told me, also the Ajke adjournment no. Enough is enough.
Could it be, my lord, subject to your lordship's business permitting, 23rd, that is Monday, at 2 o'clock?
Monday.
Oh, that matter is there.
No, Monday is too early.
Monday is the primary matter fixed.
Yes, Monday and Tuesday, I believe those are it.
Yes, those 2 days we were.
Then, my lord, Wednesday at 2 o'clock?
বুধবার কি আছে রে? বুধবার কিছু ফিক্স করেছে? কিছু সুন্দর মতো লাগে না। You won't be there on 30th, no?
Yes.
Mr. Ban.
30th, 1st and 2nd. That's what I'm saying. Keep it not on any day convenient to the court.
All right, 3rd we are giving.
3rd
July.
3rd July. দেখে নে আবার
হ্যাঁ ঠিক আছে
ঠিক আছে
sufficient
Take it up, Mr. Thor. If you can, if any other matter is in your diary, then don't give us.
No. 2 p.m. So anytime. 3rd July, anytime.
3rd July. 3rd July. Well, one. I'm really sorry. My junior friend is really sincerely assisting me in this case. Because of doctor appointments, he won't be available on 3rd. Any day on the next, any day other than. I'm the only one, not for me. Mr. Advocate General is taking.
No. I was suggesting, Miller, please keep it any day in the next week. If I get stuck up, Miller, Mr.
We want you to finish it up. No? Then Mr. Jena again has to recap it.
But only, Miller, judgments, but I don't want it to take it too far so that.
The 3rd you are there, na?
3rd I'm there.
Mr. Banerjee, you cannot make it on 3rd?
No, doctor's appointment. Very well. May I suggest one thing, my lord? On 3rd, let him finish.
Now again we have to fix.
Oh, I see, I see. No, no, I cannot disturb your lordship. It's not my inconvenience. Doctor's appointment.
Let's check up 10th July then.
10 জুলাই অসুবিধা নেই, হবে না।
তোর আবার কি হলো হার্টের রোগ?
জানি না।
ডাক্তারের বাড়ি যাবি কেন? 10th as well as my lord.
No, it is not our pleasure. We are making.
I'm
an
really
endeavor to
surprised.
fix
My lord, ask.
We have
What will be the convenient date?
two learned advocate appearing for the appellant extensively.
Give me.
I have.
So give me.
Mr. Jena, you will check it up certainly prior to 10th. You will sit with Mr. Dotto. So if you finalize the judgment, give a citation
Right,
list to
right,
them
right.
so that.
Give me that.
And Mr. Banerjee, make an endeavor to finish it on that date.
My lord, I'll be finished. No problem.
I'll be finished.
I'll be finished. No problem. I'll be finished.
That's right.
It's my pleasure to you.
Thank you.
I'm
Get
good.
developed.
Second matter is the same, my lord.
But the next matter is the same.
না অ্যাডভোকেট জেনারেল লিখো না
Merit, I am for the appellant. But I am for the respondents. Item number 13. My lord,
Here, the order of mutation, my lord. Is
my lord, the learned advocate for the respondent number 1.
Wait. What are
the assigned matter, my lord.
Huh?
This is an assigned matter, my lord.
Now, what are these applications?
Applications is one is condonation of delay, stay application, and another is, my lord, production of addition.
Not condone. Delay
Not condone, my lord.
It was before which bench?
Before just Honorable Justice Devanshu Boshak and Justice Sabba Rashidi, my lord.
So this will come under the heading assigned.
Assigned,
Assigned as an first we have to dispose of the applications.
My
Na?
lord.
Condonation of delay how many days?
167 days delay, my lord. I have narrated in paragraph from 5 to 15.
Are you opposing that? 160 oh to jane na.
I am appealing for the state, my lord.
But what happened, my lord? Initially, when the order was passed on 9th October 2023, my lord, at that time, it was a Thika property. By challenging the order of the learned Thika controller, my lord, an appeal has been preferred honorable tribunal. My lord, it was initially, my lord, opined by my erstwhile advocate that not to proceed with the appeal, first go to face the proceeding before the tribunal. That is why, my lord, they kept silent. Thereafter, in around March 2024, my lord, he sought for another opinion, and my lord,
Then you were sitting at the fence, sir. They were sitting in the fence, sitting on the fence.
yes,
If tribunal gives a favorable order, I do not go to High Court.
favorable order in my favor, that means, my lord, it is not a Thika property because I am the owner of the land, and that land Thika controller declared it as a Thika property. My lord, total 105 kathas of land.
No, Thika controller, tribunal said what?
Thika controller decided that it is a Thika property. The measurement of the land is 45 kathas.
That went against you.
Yes.
You preferred an appeal.
Preferred an appeal. My entire land is 105 kathas.
No. What did the tribunal say?
Tribunal, the matter is pending, my lord.
Pending?
Pending. The next date is on 10th of July.
Then why you
My
have
lord,
come to the, no, why the writ petition was filed then?
Writ petition filed initially. This
writ petition was filed challenging what?
My writ petition was filed by the respondent number 1, my lord. His client, my lord.
Oh, writ petition was filed by him.
By him,
During
challenging the
pendency-
order of mutation, because this land was mutated in my name.
During pendency of the tribunal matter.
That time, my lord, Thika controller has not initiated any proceeding. Thereafter, when Thika controller initiated proceeding, they have preferred a writ petition before this Honorable High Court.
10th July is the tribunal date.
Yes, my lord. But in view of that, my lord, that the matter is pending, this mutation is kept in abeyance, my lord. That order I have challenged before your lordship. But I am late.
I am accepting for the timing, I am accepting the Thika controller's order, which has been said that this portion of the land is Thika. The entire land cannot be Thika. I am accepting because there is a sub judice. I have to accept.
Then why did he file the writ petition?
He is a Thika tenant. For that he has filed a writ petition.
Who are you? Who are you?
Arm twisting litigation. If he can clock the entirety, he will gain something. But in law, I am accepting that portion of the land has been declared as Thika.
So what did the writ court direct?
The entire proceeding has been stated that I cannot be done anything. So till such time the tribunal is not deciding, I cannot use my other portion which is not Thika admittedly.
Very good, Mr. Vasu. You come back. Come back. Who is your?
I'm led by Mr. Dipayan Kundu. He's suffering from fever. That's why I am just only praying for not this week, my lord.
But there
Not
is a
today.
section 5 application also, my lord. হবে না বিয়ে করে খাওয়াইনিও কিছু হবে না
Heard Mr. Basu, learned senior advocate, appeal
Grateful, my lord.
Yes, Dr. Correct.
Item number 14, Lordship, I beg to appear on behalf of the petitioner, Lordship. The similar matter was taken up for hearing. It's a assigned matter, Lordship, is regarding the Food Control Order 2013. Similar matter has heard by your Lordship, and in earlier occasion, Lordship was pleased to fix on 9th of July. The other matter, Lordship.
9th
Although the
July,
three matters has not been tagged, Lordship, but there is no interim order in my matter, Lordship. See, the coordinate bench
will appear on 9th.
9th July, but
We
in the
conclude
meantime,
the
Lordship,
hearing, we will conclude hearing
but
this.
yes, your Lordship, but interim protection is required, Lordship. In my matter, Lordship, there is all in
No,
three.
no, no, no,
There are
no.
three matter, Lordship. On the last matter, Lordship, I require
That is 14 to
14,
how many
15 and
matters?
16, Lordship.
14, 15 and 16.
16, Lordship.
9 July. Dekha.
Lordship, interim protection may be given, Lordship.
Come and tell us on that date because we have already extended the earlier interim order till end of
But
July.
in our matter, Lordship, there is no interim order, Lordship.
Please remind us on that date.
In the meantime, Lordship, if new dealer will be appointed, Lordship, I will
No,
pay this,
you
Lordship.
there is no where is this appeal was heard by anybody.
No, Lordship. Since then, it is pending, Lordship. So far, my instruction is concerned,
When
Lordship.
it is pending since 2024. Don't
That
ask
one is
for an interim order just now. Come on 9th.
on that item number 15, Lordship, that is filed previously, Lordship. It was filed in
Item number
2025.
14 is of 2014, 24.
24 and
We are
item
in
number
25.
in item number 15, Lordship, it is filed on 25, Lordship.
Very good.
Lordship.
Very good. We will consider it. You renew your prayer. We will be reserving the judgment.
Lordship.
Finish. The 13, 14, 15, 16.
14, 15 and 16, Lordship. Then not to
What interim order you are seeking?
Lordship, not to dealing the ration holders. I am the dealer, Lordship, and I am paying for not to detag, Lordship. That we have challenged the vacancy notification in my area. And Lordship, then after in the view of the single bench was when the matter was filed, Lordship, there is a stay order that you may proceed with the selection process of the vacancy notification, but not to reach it finality.
All right,
Subsequently,
then
Lordship,
you give a notice
that
to
the
your other
coordinate
side.
bench, the interim order has been passed that not to dealing the ration holder beneficiary who are under my
Give a notice to who you are appearing for
Yes,
the
sir.
other side. Come back on Monday.
on Monday. Grateful to you. 15 is appearing, Lordship.
He's praying for that interim order.
Your Lordship, this was heard, and these matters were tagged with those matters which are being already heard by your Lordship,
So,
which has been fixed.
in those matters, there is a something interim order.
Yes, your Lordship, but in that case, your Lordship, give me 1 minute. Your Lordship, in item number 15, the case is slightly different because, your Lordship, here the license had
Come back
already
on
been
Monday.
granted.
Come back on Monday.
Grateful.
Yes, next.
Grateful to you.
14, 15. Monday না এটা এইগুলোকে keep it on Wednesday. It will be
Wednesday.
there.
On Wednesday.
Yes, next.
Grateful, your Lordship.
Blood,
Yes.
state respondent.
But I'm late, Mr. Surjit.
You are led by?
Mr. Surjit Nath.
Huh?
Mr. Surjit Nath Mitra.
What is the matter of?
The matter relating to appointment to the post of Group D. But on post was declared vacant. The petitioner and the private respondent and others appeared in the selection process. Now the petitioner got selected.
The order.
অর্ডারটা বার করো না লাস্ট অর্ডারটা ডিআই এর যেটা ডিআই অর্ডার স্কুল যেটা ওকে দিতে বল
হ্যাঁ এই প্রবলেম পরে অন্যদিন করবে পরে খবর
Yes,
my lord, I have some difficulty at 2 p.m. my lord
Can it be taken up on some other day? I'm sorry, my lord. It's a matter fixed at 2 p.m. না তো তুমি করো
Not today করে রাখ. Come back on Friday. Tomorrow, if it is reached, please.
Sorry.
Tomorrow, if it is reached, then Mr. Mitro, you. ও কালকে তো শনিবার. Sorry. চলো ডেকে দাও.
কবে হবে তাহলে?
My lord, item 19, my lord. My lord, the very next matter, my lord, the item 19. Will it be my lord's pleasure to take it up on Monday or Tuesday, my lord?
My lord,
I appeal for the appellant.
is also there, my lord, for today. He's on his way, my lord.
You are the other side.
Yes, my lord. In the 19, I'm on the state, my lord.
That's not today করে রেখে দিও 19টা.
My lord,
3টা ডেকে দাও.
Not today.
My lord, 20, my lord, I will not be available at 2 p.m. My lord,
Your junior.
my lord, get
Yes.
My lord, I am both ashamed and all full of humility. Your lordship had one of my review application once. Your lordship engaged additional government pleader to appear on behalf of the respondent. Then your lordship fixed it sometimes in July 2023, my lord. Thereafter, matter could not be heard. Review application group 9 matter, my lord.
Give the number, দেখে
I have written all the thing in detail, my lord.
Review কি কার order ছিল? Review of whose order?
My lord,
Review of whose order?
review has been allowed, my lord.
So then
Now, my lord, FMA is to be hard on merit. Review is allowed, my lord. Review was order has been reviewed by Honorable Justice Odindam Sinha Rajoshi Bharatbhai. Review has been allowed by your lordship. Details I have given, my lord. If your lordship kindly sees to looks into it, my lord. And
group 9 এর ম্যাটার হলে দিয়ে দাও। Yes, call the list.
May it please your lordship, sir. I beg to appear on behalf of the appellant, my lord. But as I was submitting yesterday, my lord, there is a leave to appeal application, my lord. I'll run very briefly, my lord, through the facts of the case. Now, on the basis of the letter issued by the appellant to various authorities pertaining to filling up of a pond, my lord, which is measuring around 5 bighas in Regjwani area of Rajarhat. The National Green Tribunal suo motu registered a case on the 16th of April 2025. The first order was passed, wherein the district magistrate and the West Bengal Pollution Control Board were impleaded as party respondents. A fact-finding committee was formed by the National Green Tribunal with a further direction upon the district magistrate, who was heading the committee, to file a report on the returnable date. The returnable date being the 19th of May 2025. Now, my lord, will find the first order at page 33. It was recorded therein. The contents of the letter was also recorded. 33 of the stay application, my lord. It's the first volume. My lord, may I just place the first order, my lord? Now, Mr. Sachin says the applicant is present in person.
You are the person who are one.
My lord, I am the appellant here, my lord. The present original application is being registered on the basis of a letter petition dated 26/3/2025 and 31/3/2025, received in the office of the registry, National Green Tribunal, Kolkata, filed by the applicant Narottam Datta Rai, Regjwani Grambashi Brindo, alleging that a large pond measuring about 4 to 5 bighas opposite the playing field of the RFA club is being filled up, particularly during night hours, on an alleged permission granted by the district magistrate. The allegation in the letter petition is as under. There is a large pond measuring around 4 to 5 bighas located in our area. The details of the pond are as follows. Thereafter, the details have been spelled out. This century-old water body is currently under an attempt to be filled, particularly during the night hours. According to the Rajarhat police station, permission to fill the pond has been granted by the district magistrate. Now, this is important, my lord. However, the villagers have opposed filling of the pond, and as a result, the police have threatened to arrest us. Recently, when some media personnel arrived, the police jeep immediately left the scene. Due to the villagers' resistance, the filling of the pond has been temporarily halted. There are rumors that the pond has been sold for promotional purposes, though we are still unclear about the situation. According to the current regulations, regardless of the pond's records, no water body can be filled up. The ongoing filling activities are being conducted without adhering to proper administrative procedures. This pond is a point of pride for our village and plays an important role in the environmental conservation. It is essential that this pond remain intact for the benefit of the community and the environment.
Now, thereafter, my lord, para 4, the matter requires consideration. We direct the following members to be implemented in the array of respondents. Accordingly, my lord, the district magistrate of North 24 Parganas, the Department of Environment, Government of West Bengal, and the West Bengal Pollution Control Board was implemented, my lord. And thereafter, my lord, the para 7, Mr. Such and Such accepts notice on behalf of the respondent numbers 1 and 2, that is the district magistrate and collector and the Department of Environment State. Mr. Such and Such appearing in virtual mode accepts notice on behalf of the West Bengal Pollution Control Board. Thereafter, para 10, considering the allegations made, we deem it appropriate to constitute a fact-finding committee comprising of the following members. So it was the district magistrate and the senior scientist, West Bengal Pollution Control Board. The committee shall visit the site in question and thereafter submit a fact-finding report on affidavit within 4 weeks with regard to the allegations made in the letter petition. The West Bengal Pollution Control Board shall also inspect the site in question and submit its inspection report on affidavit within 4 weeks with regard to the allegations made. The district magistrate shall be the nodal officer for all logistic purposes and for filing of the fact-finding report on affidavit. Applicants shall serve soft copy of original application to such and such within 24 hours. Now, this was the order passed, my lord. Now, on the returnable date, my lord will find page 37, that is on the 19th of May 2025. Now, there was an intervention application, IA number 51 of 2025, which was moved at the behest of the writ petitioners, respondents herein, my lord. Now, my lord, the order goes on to record that learned counsel appearing page 37, my lord. The learned counsel appearing for the district magistrate stated that the inspection has been conducted, but joint committee report could not be filed, and he seeks 2 weeks further time to file joint committee report. IA number 51 of 2025 has been filed by 18 parties, seeking their impleadment as respondents in the present original application, stating that they are the parties likely to be affected if any order in favor of the applicant is passed. Learned counsel for the IA applicant stated that copy of the IA has been served upon the applicant Narottam Dattorai, but there are certain facts on which aspects the state authorities have necessary information. Hence, in our view, let the copy of this IA be served upon the respondent numbers 1, 2, and 3 through their counsels within 1 week. Applicants and respondents were granted 3 weeks time, my lord, and the matter has been next listed on the 11th of July, 2025. Now, my lord, at this juncture, when the issue was being adjudicated, my lord, by the National Green Tribunal, now on the 20th of May, the interveners before the National Green Tribunal, as writ petitioners, my lord, moved an application before the Honorable Single Judge alleging police inaction.
When was that?
That was just after a day, my lord.
No,
after this.
just after that was the order passed. When was the writ petition filed?
My lord, the writ petition was affirmed on the 7th of May 2025.
And they filed the intervening application?
My lord, the intervention application, I'll give your lordship the date of filing. The impleadment application, page 39, yes.
Same day, my lord. Same day.
7th of May. Page 39, my lord, will find the impleadment application with the stamp of the notary, my lord, which records that it was also, my lord, filed on the 7th of May 2025.
They did not say anything in the
There is not a, no, there is not a single whisper.
But
the
both
entire
the
pleadings,
intervening application as well as the application for writ petition was affirmed on the same date.
my lord, I find, my lord, it was noted, the intervention application was notarized on the 7th of May 2025.
And the
writ petition was affirmed on the 7th of May 2025.
Yes.
Writ petition, my lord, I have procured a copy from the Sharthok website, my lord, which is available. The writ petition is at page 355, my lord. It has been annexed. Memo of appeal to the memo of appeal to the memo of appeal to the. Look at the name of it, you know. Right.
No, the conversion is apply.
So, my lord, kindly, if my lord, take pain to come to the judgment and order which has been assailed in appeal, my lord.
But that land they have converted. They
My lord, what happened is, my lord, they were trying to fill up, my lord, the pond. There was
What
partial,
pond is at Dag number? Which Dag number?
my lord, the pond is at, I'll tell you, lord.
1176.
My, it is, my lord, plot number 579, Khotiar number 1176, Mouja, Rekjuani.
Where you are reading?
My lord, page 33, my lord, of the order passed by the National Green Tribunal.
So, Mr. Bagh, why didn't you disclose this?
Once my learned friend, my lord, finishes his submissions, I'll indicate everything. My lord, I am expecting that he will indicate all the facts. Otherwise, I will. My lord.
Yes.
Now, my lord, kindly take pain, my lord, to come to the order assailed in appeal, my lord, which was just within 24 hours, my lord, after the intervention application was moved before the National Green Tribunal.
They didn't disclose this.
My lord, first of all, they didn't disclose. Secondly, my lord, the state, that is the inspector in charge, Rajarat Police Station, they filed a report stating the same fact which was recorded by the National Green Tribunal in its first order. That there is, the report discloses that the Rajarat Police Station has admitted that proportionate area has already been converted into pond in respect of the area for which construction is being raised by the petitioners.
Where you are reading?
My lord, page, the impugned order, my lord, the first page.
Report submitted by state.
Yes, my lord. State has submitted a report. The report contains the inquiry which was conducted by the inspector in charge, Rajarat Police Station, wherein it is admitted that proportionate area has already been converted into pond in respect of the area for which construction is being raised by the petitioners.
But
And the
there
grievance of the petitioners has been recorded in the preceding paragraph. The petitioners are aggrieved by the fact that in spite of permission being granted by the appropriate authorities, they are unable to carry out their construction work because of interference and or obstruction created at the behest of the local miscreants. Same stand, my lord, which was taken, my lord, before the National Green Tribunal 24 hours prior to passing of this order. But, my lord, there is not even a communication, my lord, that we have already approached the National Green Tribunal, or there is something pending before the National Green Tribunal. But in view of the fact that they moved this interim application, the intervention application before the National Green Tribunal, but it cannot be denied, my lord, by the writ petitioner respondents, my lord, that they had knowledge about pendency. Because in the application also filed before the National Green Tribunal, they have admitted that they have gathered knowledge.
Now, fact-finding report has not yet
No, on one hand, my lord, the district magistrate is seeking extension of time to file the fact-finding report, and within 24 hours, my lord, from the date of the proceeding before the National Green Tribunal, the state, on the other hand, these are all instrumentalities of the state, my lord, filing report, my lord, siding with that of the writ petitioners, my lord, prompting the court, because, my lord, the honorable single judge is not supposed to know the facts. The facts, my lord, it is the obligation of the persons knocking the doors of justice under Article 226, my lord, to place on record all the correct facts. But unfortunately, my lord, there is not a whisper. This is, my lord, I say, in terms of, my lord, the judicial pronouncements, this is a case of sheer fraud which has been played on the process of justice,
Yes,
my lord.
yes. Anything else? Mr.
Yes, my
Murali?
lord. So, my lord, the honorable single judge further goes on to record in the internal page 2 of the judgment, my lord, having regard to the fact that the police authorities are having knowledge regarding the incidents which have been reported and for which the petitioners are also aggrieved, I am of the view that the police authorities will keep a surveillance and ensure that the petitioners be not obstructed and or any untoward incident results because of continuation of the work of the petitioners. Now, my lord, on the score of this particular observation, attempts were made, my lord, to fill up the pond once again. Now, a substantial portion was also filled up, my lord. Then, my lord, there was resistance by the, my lord, local villagers, the local persons, my lord. Then, my lord, the police disclosed to us that no, there is a High Court order, the order passed by the Honorable High Court. And thus we gather, my lord, knowledge about the order. And, my lord, thereafter, my lord,
What is the present status?
my lord, the present status, we have annexed photographs, my
Why
lord,
didn't
will find.
you tell to the tribunal that they are making a construction? You have
Yes, it's my lord,
they are attempting to fill up.
yes, because that was, my lord, in the month of March, the letters were given and the Honorable Tribunal, my lord, registered a suo motu case, my lord.
Now, what is that act? And there is a bar.
Section
under here?
29 of the National Green Tribunal Act, my lord. In addition thereto also, my lord, There is a
But,
cut,
how you can be a person aggrieved, Mr. Bhattacharya?
but there is a petition, a proceeding, my lord.
No, as regards suppression, Mr. Bagh will reply.
My
But
lord.
we are asking you that you are a local resident.
But I am a local resident.
You have made a complaint to the.
I have made a complaint. On the basis of my complaint, my lord, a
But what
proceeding.
is your right which is being interfered?
My lord, we are, my lord, the local inhabitants of that particular area.
One person has.
No. This is on behalf of, my lord, the local inhabitants, my lord.
Where is that
My
application?
lord, I'll tell you, lordship, my lord. Well, just want to show one letter, my lord. চিঠির কপিটা কোথায় আছে বার করো yes my lord, kindly takes page 31. These were the letters, my lord, which were sent.
Right, but how you are a person agreed, Mr. Bhattacharya?
My lord, we are Rajarhat Rekjoani Grambashi Brindo. We express our deep concern regarding a matter that directly impacts the heritage and ecology of our Rekjoani village, my lord. Page 31. So, my lord, on behalf of the villagers, my lord, I am one of them, my lord. I signed on it. And I had sent it to various authorities.
Complaint is 31st of March.
31st of March, my lord.
This is not by Narottam.
This is by Narottam, my lord. This was signed by Narottam.
Where this is.
My lord, I unfortunately do not, it does not contain, my lord.
Grambashi Brindo.
Yes. Grambashi, it was signed on behalf of the Grambashi Brindo, my lord. It was signed by Narottam.
So, Mr. Bhattacharya, how you are person aggrieved, tell us.
No, my lord, I say my contention is, my lord.
You have brought to the notice, you are a whistleblower.
My lord, in terms of, my lord, the NGT Act, I am a person aggrieved, my lord. In terms of the provisions contained in the NGT Act, my lord, I'll tell you, lordship. But section 14, my lord, I only have one copy, my lord. I apologize, my lord.
Section 14 of
the NGT Act. Section 14 of the NGT Act.
Lord, here's another copy. My lord. Give him. Same copy, actually. Copy,
The other copy is also there. I'm grateful to Mr. Bagh.
Yes.
And my lord, the query of the Honorable Court, my lord, that has also been answered in para 2, my lord, of the first order passed by the NGT, my lord, on 16/4/2024. It records a letter petition dated 26/3/2025 and 31/3/2025 received in the office of the Registry of NGT filed by the applicant Narottam Datta Rai, Rekjoani Grambashi Brindo, alleging that a large pond measuring, my lord. So it is not my personal, but I am representing, my lord, the local people of that area, because, my lord, the entire biodiversity, my lord, will be affected, and, my lord, that is squarely covered by section 14 of the NGT Act. My lord, the powers of the writ court, my lord, are plenary, and, my lord, that cannot be curtailed by, my lord, any act, my lord. There is, my lord, a bar engrafted under section 29 of the NGT Act, my lord. Section 29 says that from the date of enactment of coming into effect of this particular act, all questions have to be tried by the NGT. But this has been again interpreted by the Honorable Supreme Court of India in 2012, my lord.
Yes.
The Honorable Supreme Court of India in 2012, judgment judgment. It is reported in 2012, volume 8 Supreme Court cases, page 326. The relevant paragraph is, my lord, paragraph 40. Now, the Honorable Supreme Court records that keeping in view the provisions and scheme of the NGT Act 2010, particularly sections 14, 29, 30 and 38(5), it can safely be concluded that the environmental issues and matters covered under the NGT Act Schedule 1 should be instituted and litigated before the NGT. Such approach may be necessary to avoid likelihood of conflict of orders between the High Court and NGT. Thus, in unambiguous terms, we direct that all the matters instituted after coming into force of the NGT Act and which are covered under the provisions of the NGT Act or in Schedule 1 to the NGT Act shall stand transferred and can be instituted only before the NGT. This will help in rendering expeditious and specialized justice in the field of environment to all concerned. Now, my lord, it was within the domain of knowledge of the NGT that the district magistrate has permitted the conversion. Now, the specialized justice in the field of environment, my lord, as the Honorable Supreme Court records in para 40.
Tribunal was aware that.
Yes, it has recorded. That is, in the first order, it has been recorded categorically that the IC of Rajarhat states that it is being done.
That is the reach court order.
No, that is, my lord, page 33, the first order, my lord, filed, passed by the tribunal.
Yes.
Because it was mentioned,
Para?
but paragraph 3.
That is your letter.
Yes, in the no, the tribunal had taken cognizance of what the facts stated in the letter. The last line, my lord, paragraph 3. According to Rajarhat police station, permission to fill the pond has been granted by the district magistrate.
Paragraph 3.
Page 33, my lord, at the bottom, my lord.
According to.
Yes. Now,
so a fact-finding committee was.
Despite that, a fact-finding committee, my lord, was constituted, my lord, by experts, and a report was called for. Now, my lord,
pollution also gave a report.
My lord, both of them prayed for extension of time, and on the other hand, my lord, the Honorable High Court was moved without being even intimated that there is something pending before the NGT. This is my first contention, my lord.
Now, this judgment you are relying for what proposal?
My lord, for the proposition, my lord, that when, my lord, this was essentially to be tried by the NGT, and it was in fact being tried by the NGT, and it is not the case that the writ petitioner respondents have not availed of approaching the NGT. They in fact filed an application and approached the NGT.
Why they will approach the NGT? They want to raise construction.
No, they have approached. That is exactly what they plead.
That is after the.
That is after the matter was registered.
They approach.
Yes, they approach by way of filing, my lord, the impleadment application. And on the other hand, my lord, they approach the Honorable High Court, my lord. This is a clear case, my lord, of pursuing, my lord, parallel remedies, my lord, parallel proceedings. Now, they allege in the writ petition that there is a 144 order which has been passed
You
by.
have not answered our question.
My lord.
How your person agreed?
My lord, section
What is the violation of your legal or?
My lord, section 14, my lord. I have availed my rights under section 14. My lord, it is not the case, my lord, that I personally filed a petition before the NGT. It was on the basis of letters sent to various authorities, my lord. The NGT that thought it prudent, my lord, to suo motu register a case, my lord. In fact, my lord, in my experience, my lord, this is the first time I am dealing with a case, my lord, where the my lord, National Green Tribunal has suo motu registered a case.
Yes, Mr. Bhatt.
But the other two judgments, my lord, I will be citing, my lord, very short judgments, my lord. One is, my lord, on the point of, my lord, pursuing parallel proceedings, my lord, which is barred, my lord. It is reported in judgment of the 2006 volume 4 Calcutta High Court notes, page 847, paragraph 11. This was following Gokak Patel Volkert's case, my lord, which was reported in 95-1 SCC page 642. That one cannot avail of parallel proceedings, my lord. Paragraph 11, my lord. Yes, it's 2006 4 CHN. Arekta copy থাকলে দাও না দিয়ে দি। Page 847. CHN page 847, para 11.
Can it be said that they have pursued parallel remedies?
Yes, yes, because
they got involved.
Their application has been registered. Their application has been registered.
Addition of party.
Yes, they intervened. Their application was
Addition of
registered.
party.
Yes, and it is not the case that their application has been dismissed.
Parent proceeding was initiated on the basis of your application. They
The
want
parent,
to
yes,
add
yes,
themselves.
Yes,
They have not pursued a
No, they
parallel.
say that our interest will be affected. They say our interest will be affected. So, my lord, this is the second.
They are defending. They are not pursuing it.
My lord, they are parties, my lord, I will say.
Not yet.
They are intending parties, or my lord, there is, my lord, an interlocutory application pending at their behest.
What interlocutory application?
The IA, my lord.
That's
the
addition of party.
But
That's
that
an
is an
interlocutory application.
an application, my lord. But I am submitting this, my lord, in order to, my lord, bolster my contention.
The NGT passed any interim order? No.
But the report, my lord, the report and thereafter, my lord, this sought for extension of time, my lord. But the third ground of, my lord, attack, my lord, is, my lord, the question of fraud, my lord, which is the most important, my lord, in, my lord, discretionary proceedings, my lord, under Article 226, my lord. I will be just relying on one judgment, my lord, not Chengalwadi and Naidu, my lord. It's reported in 2008, 12 Supreme Court cases, page 481. It's KD Sharma, my lord. The relevant paragraphs are, my lord, paragraphs 26, 27, 34, 36, 38, and 39. Now, this squarely covers my case, my lord.
We are not deciding the writ petition, Mr. Bhattacharya.
My lord, it's a finally decided.
Account.
It's a finally decided writ petition, my lord. My lord, I am, my lord, assailing that order, my lord. My lord, KD Sharma, the judgment, my lord, that I am citing, my lord, that goes on to record, my lord, in fact, that para 27, that, my lord, at every stage, my lord, I can raise the point of nullity. Whenever there is, my lord, a fraud perpetrated, my lord, on the honorable court, it, my lord, records the observations made in, my lord, A. Papaya Shastri's case. And it, in fact, quotes, my lord, para 22, stating that it is just thus as para 27, my lord, I am placing a settled proposition of law that a judgment, degree, or order obtained by playing fraud on the court, tribunal, or authority is a nullity and non-est in the eye of law. Such a judgment, degree, or order by the first court or by the final court has to be treated as nullity by every court, superior or inferior. It can be challenged in any court at any time in appeal, revision, writ, or even in collateral proceedings. Well, that apart, my lord, the relevant paragraphs, my lord, as I was saying, will be, my lord, para 34, which deals with, my lord, the discretionary jurisdiction which is being exercised under Article 226, and, my lord, the duty of the litigant knocking the doors of justice, my lord. And, my lord, may I just place the paragraphs? These are not very lengthy paragraphs, para 34 and onward. The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. But thereafter, R versus Kensington has been quoted. And thereafter, my lord, para 36, my lord, a prerogative remedy.
We are on the limited issue of addition is required or not. This is your anyway. We feel we have not stopped you from showing anything. Anything else you want to say?
These are the my grounds of challenge, my lord.
Yes, Mr. Bal.
Wait, please, my lords. My lords. I thought the submission would be holistic. It is extremely myopic because the entire facts are not stated.
No, you must satisfy us.
My lord, as to why those two dates, why did we approach the two forums? For that, I'll indicate, my lord. It is not required and I'll indicate why.
Why?
My lord, the appellant, the person who is now wanting to be added, my lord, for leave to file appeal, the petitioner, but he issued a letter to the NGT, which is recorded in the first order of NGT. I'll step back a little, my lord, to give the clear picture as to why, my lord, it is not required at all, and I stand by it. For that, I have to show a few documents. But this is a construction project which was coming up. We have been, my lord, adhering to every step in law. Kindly permit me, and what is not stated is this, and I'll have to show this. My lord, they knew that we are the owners. We are the owners of these plots. We are the ones who are constructing. They knew that. Of course, there are other considerations, my lord, for which we did not agree. And they approached the NGT on the premise that we'll not let you work. You see what we do. They don't make us a party in the NGT. They write a letter to the NGT to proceed. What is the challenge? The challenge is that there is a pukur which is getting filled. They have annexed in this proceeding the conversion. Conversion is allowed. And after the conversion, there's a duty on us within 90 days to shift this and make another pond in a bigger area or an equal area. We've done that. That's on record. I'll show that. So 0.74 acres was the original plot where there was a pond, and I'll show that from the records. I thought this will be submitted by my learned friend.
So maybe
0.76 is it has been now converted. 0.76 immediately in accordance with law. This was done. I'll indicate, my lord, I'll indicate. We had filed a petition under.
Say it was not necessary to be pointed out.
It was not. I'll indicate, my lord, why. But we wanted to be added as a party in the NGT proceeding to indicate to the NGT, which we will, my lord, once we are added. We have not been added. It's only directed to be served. We don't have an order in our favor. We are not even parties there. The domitous litis is on them. They instituted the proceeding before the NGT, not making us a party. We came to know of that order. We approached with the petition for addition of party. We don't have.
They did not file a formal application. They made a letter.
They made a letter addressing the NGT.
Has suo moto accepted
it's not suo moto, the letter was addressed to the NGT for consideration and suo moto registration of case.
The proceeding initiated. They
in NGT, may I very humbly submit, in NGT, my lord, 90% of the matters are, my lord, filed in this manner. My lord, where a letter is issued, and then, my lord,
can you say that they did?
I don't want to. I don't want to, because my case
did
is.
Not add us. This you cannot say, no?
I'll indicate, my lord. They knew fully well, and I'll show it from the records. It's
you thrash it before the.
No, I'll do so, my lord. Kindly bear with me for 5 minutes before I show the documents, which will clear out the issue. My lord, in the sale deed, there are a few things which I need to show. We have invested, my lord.
We have asked an answer from you that on 7th of May.
Why did we not disclose?
You should be clean, no?
We are, my lord. I indicate why. Kindly do not hold that against us. I'll
tell the court.
Lord, that is because this proceeding is from a proceeding where we have an order under 144. I'll show that order. We had filed, my lord, before the executive magistrate, a 144 petition.
Maybe.
There's an order in that you have. No,
right.
kindly bear with me.
You will not tell us that, sir, this is the.
It is not required. I'll indicate why. My lord, kindly bear with me for 5 minutes. I'll indicate why it is not required. My lord, in that proceeding, we have an order. I have to show that order. That order my lord, before that, may I show the other parts or should I come back to these parts?
No, no, we are not
Very well, my
satisfied
lord.
with your answer as
My lord,
regards.
kindly take up, I'll indicate, my lord. Kindly take up page 335. 16th April 2025.
335.
This is the Genesis 335, my lord, of the stay petition. Which volume is it? It's the third volume, my lord.
Uh-huh.
11th of July.
11th July.
My lord, may I only indicate what is the genesis of that writ petition which we had filed for police in action? This is the genesis. My lord, kindly take up page 335 once. Because they were not allowing us to work. So, my lord, we had to approach. Kindly see page 335. Kindly see the date first, my lord. It's volume 3, my lord, 335.
Yes.
But 16th of April 2025 is the date. Petitioner filed a petition, Vakratnama, along with necessary documents. Through learned advocate, BL LRO Rajarhat is directed to cause enquiry into the matter and also submit a report by the next day. IC Rajarhat, in the meantime, IC Rajarhat is directed to inquire into the matter and submit a report by the next date. Kindly mark this next portion, my lord. He is also directed to keep a strict vigil on the law and order situation of the area concerned. This was not happening. This was not happening because, my lord, every day we went there, my lord, we could not construct, my lord, we could not carry out with the work of, my lord, the shifting of pond, and that is a statutory mandate. I'll indicate that from records. We have a time frame within which we were required to do this, 90 days. That's indicated, my lord, from the conversion report. Two things, my lord, here come. One, because of this portion, my lord, where the police was not, my lord, giving us that assistance, where, my lord, there was peace to be maintained. The local hooligans were coming and threatening us that we will not allow you to work. That's the genesis of the police in action writ, my lord, which we moved. It has nothing to do with the NGT, my lord, NGT portion of the entire proceeding. Now, NGT, I'll indicate, it's not maintainable. I've made that submission there on the last day. I was told that when you come back and you are added once, you make this submission. I'm carrying those judgments. What is the grievance, my lord? They have not shown that there's a valid conversion certificate. They have not shown that this pond has now been made in a different place, which is our area. I'll indicate that from the records. Kindly take up, my lord, the sale deed.
90 days you are saying? What is the
That's, my lord, in the conversion, there's a certificate where, my lord, this conversion is permitted. That's from Danga to Pukur. Because, my lord, there was other party.
Subject to making a pond in a separate.
We have made that pond. That's on record.
That deduction is under the Fisheries Act, no?
In the Wetlands Act, my lord, that's there. I'll just show that, my lord. It's 90 days is indicated. That's on the record. I'll quickly show that.
90 days for making
for conversion, for making that land into pond again. So, my lord, from the date of conversion, my lord, we have to equate. So, 0.74 acres where there was pond, we had to shift that to 0.76 acres where we converted it into a pond. The land was converted into pond. And that process was to be done within 90 days. We were doing that. That is where they obstructed that. Of course, they had other demands. We did not meet that. And that is when, my lord, we approached for a 144 order. We got that order. But still, my lord, this was not being, my lord, implemented because we were not getting, my lord, that protection. We could not do that because that would be a statutory violation. Hence the writ petition for police in action.
What would have been a statutory violation?
But 90 days, within 90 days, if we can't do it, I'll show that quickly, my lord. But may I first quickly indicate there are 4-5 documents I want to show, my lord. Kindly take up the sale deed, which is at page 59 onwards, volume 1. Please tell me the volume. Volume 1, my lord. I only want to show it starts from page 59. Kindly take up page 116. 116 and 119. These two documents, I'll show what was the consideration for which we bought this property. Almost 14 crores. Page 116, your lordship will find the total amount starts from page 82, my lord, there's one deed, starts from, my lord, it's page 116, the total amount, 1042, so 10 crore 42 lakhs odd. With this, your lordships will be pleased to take up page 199. This is the other deed where, my lord, the consideration amount is given. Page 199, my lord. Tell me the volume. That's volume 2, my lord. The second volume, my lord. Please keep telling me the volume. Page 199 at the bottom, my lord, 1 crore 40. It's a big project which we have taken out. My lord, now, kindly see the schedule. This is very important, my lord. It's page 82. That's the schedule of the property. Kindly take up directly, my lord. May I request your lordship take up the conversion certificates at page 216 first, so that I can clear up that 90 days period, my lord. Page 216, volume 2, my lord. The second volume. Page 216, my lord. Your lordship will find at the right hand top, there are two dates, my lord. 18th of March and 19th of March 2025. Now, this is the date when we had applied. I'm sorry, my lord, this is the when the certificate was given. The application date is, my lord, reference his or her application date 13th of February 2025, the top, my lord. Kindly see schedule 1. Kindly see the, my lord, LR plot number 579. Kindly mark this, my lord. Page 216, my lord. There's a table, my lord, it's 579. Your lordship will kindly see classification Pukur and classification, I'm sorry, my lord.
Yes. Bahutal Avasan.
Bahutal Avasan. So from Pukur to Bahutal Avasan. And kindly see schedule 2 there, my lord. Terms and conditions over the page E, page 217E, my lord. Where the application relates to permission for change, conversion or alteration of any land having a water body. The order allowing change, conversion or alteration is subject to creation of compensatory water body of equal or larger size of such water body within a period of 90 days from the date of issue of the order granting change, conversion as sought for is made. That's the mandate, my lord. Now thereafter, kindly take up, my lord, the other. Yes, Lord, without doing this, my lord, junior is right, without doing this, we will not get the conversion, my lord. Lord, kindly take up page 252 thereafter. (252) is for the other plot, my lord. Very similar. Kindly see schedule 1. Dark number is given, my lord, 1176. This is from Danga to Bohustol Avasan. Danga to multi-storied building, my lord. Page 252, very similar terms. Kindly take up, my lord, thereafter page 288. Which volume? Volume 2, my lord. 288. This is very important. At the top right hand, your lordship will find the date of the certificate, 18th March. The application was 18th February 2025.
252 is of July 2023.
That's the other Danga, my lord. That's 1176. That is not with Pukur. That is nothing to do with Pukur.
No, that is Danga. Why you are showing us this conversion to Danga is converted?
Danga is converted. Only the certificates that we have. There are 4 certificates, my lord. These are the 2. And in one, there are 2, my lord. That's what I'm now indicating.
No, where you are making the compensatory.
I'm very grateful. That's 288, my lord. Page 288, volume 2. Your lordship will find 2 plots given, 413 and 423. Kindly see it is Bagan to Pukur and Danga to Pukur. Your lordship has found that, my lord. This is page 288, your lordship.
This is also your purchase.
This is also our purchase, and now I'll show from a chart what is the complete area. Your lordship will kindly take up page 324, volume 2. Volume 2, my lord. Page 324. These are our purchases, my lord. 413 and 423 at page 288 is the conversion. Now, this is bigger than the original Pukur. I'll show that. Your lordship will kindly take up the chart at page 324.
Yes.
My lord, kindly see.
No,
there is.
we accept it. We accept.
These are the
Mr. Bagh,
My lord.
you go and tell this to the tribunal. Let the
We have to.
application
For that,
be
we have to be added as a party, and also we'll tell this to the.
Then in the meantime,
My lord.
if you go on with the construction.
We have to, my lord. I'll indicate what is the premise of my learned friends, my lord. I'll indicate that. First, they have to show, and I'm carrying that judgment of the Honorable Supreme Court, my lord.
Now 90 days will be over by.
It is over. It is over, my lord. Now we have, in fact, we have converted. It's done.
Then
The only reason why they have not approached the suit court. We have done that, my lord. The only reason we had to approach the Honorable Writ Court is because we were not able to do it within that time.
Today
it is converted.
Converted.
It is converted.
So you solve the problem, get that.
But
Get
there are
that
two
order
things.
from
Indeed,
the.
we will.
No, no, let us
My lord.
understand.
I'm sorry, my lord. I'm sorry.
We are not in an adversarial level.
Indeed.
We are wanting to solve the problem.
Lordship.
Your contention that these people are there for some other means, maybe.
Indeed, my lord.
That he is there preventing you from doing. Now it has crystallized into a proceeding under the before the NGT.
No, my lord.
NGT has fixed it up on 11th of July.
My lord.
So you stay your hands till 11th.
That will be an order against me when there, my lord, is no
give
cause of
your-
action.
You give your undertaking to
We
us.
can't. I'll indicate why, my lord. I'll indicate why.
So
kindly take up.
Suppose we allow your prayer,
My lord.
and we do not allow them
For
to.
that, I'm sorry.
Suppose we allow your prayer and we reject their application.
It has to be. I'll indicate, my lord. In the next 5 minutes, I'll indicate. I'm sorry.
We are wanting to say that suppose we do not entertain Mr. Bhattacharya's leave to appeal.
My lord.
For XYZ reason.
My lord.
But still, your NGT proceeding remains.
That's an independent proceeding. We'll fight that. There's no stay.
Mr. Bagh,
today,
you have to satisfy. Once a proceeding is in ceasing,
my lord,
where you want to be added because you want to point out the correct facts.
I want to. Yes, my lord.
So you will tell the tribunal that you dismiss this application because statutorily I have been given the authority to raise construction.
Very grateful, my lord. Very grateful.
And on that date you get a further that because this construction, if they still await, then you are free to take up this issue.
May I only submit this? When I have followed what has fallen from your lordship. Now, today they have not. They don't have an order of stay from the NGT. Today, my lord, they don't have an order of stay from the NGT. So, if your lordship, my lord, today impose an order on us, it would then mean what they could not do in a suit, and I'll indicate why they did not file a suit. But this is a
we do not give them the. We will say we are remanding back the matter to the single judge.
But for the writ court, my lord, where my allegation was police inaction. Today they have to first show, and I'll indicate, my lord, the premise of person aggrieved because I'm carrying that decision.
Court been aware of NGT, court would have at least given its mind to the objection.
But may I only indicate this? Today, my lord, if my learned friends are aggrieved in any manner, my lord, with the conversion, that's what they are saying, my lord. That's what they're saying, that we are aggrieved by the conversion. Right. There's a report which is awaited. Kindly take up. Kindly.
No, they are aggrieved. They have not said so. Their claim is very. What should I say? That some kukur is being filled up. My lord, kindly interfere.
Yes, and without knowing.
So, tribunal says, all right. You have made an allegation.
We'll inquire into it.
If it is right, we will go.
Indeed,
if it is wrong, you will face the news.
Indeed, my lord.
You will face the music.
My lord.
So that you will be open to the tribunal for you to
It is always open to the tribunal, my lord. The difficulty today which we will face, if your lordships pass, my lord, an order.
Mr. Bagh, after this fact, you tell us what will deter us from allowing you to go with the construction.
My lord, I'll indicate why. My lord, today, if my learned friend, I followed, my lord, may I only submit this? with the three judges bench decision.
Now, any other paper you want to show?
I want to, my lord, but only this, because today if I go into the merits, I'll have to waste your
Yes.
lordship's time. First, they have to satisfy whether they are, my lord, fulfilling the ingredients of person aggrieved. I'm relying on a three judges bench of 2020, my lord, where the definition has been explained as to who is a person aggrieved. They don't fulfill this criteria. And I'll indicate to your lordships why they don't want to go ahead and
What is the present status?
My lord,
in your property?
in the property, my lord, it's a project, housing project which is coming up.
It has started.
18 companies, my lord, 18 who are all, my lord, the respondents. 18 companies have formed, my lord, a JV, and they are constructing a huge project in Newtown.
No, has it started?
It's work in progress.
Work in progress, my lord. So if your lordship not pass an order of stay, they have a huge loan, my lord, they are reaping. So it's a commercial angle, my lord. Today, if there's a stay on us, my lord, then the project will get affected. And there has to be, my lord,
Satisfy, no, not agree person, except plus these documents.
My lord, my lord.
Mr. Bug, had this
It is
been one line been pointed out, trial judge would have called them if necessary, finished it up.
But we understood that these are two separate proceedings because we were, my lord, from that 144 order,
It is a
non-implementation.
separate proceeding, but it emanates from the same subject matter.
My lord, may I only indicate this? My lord, I leave it to your lordship. My lord, may I only indicate this instead of going into the merits right now? But may I keep my submissions limited because I understand, my lord, perhaps they will not be able to cross this threshold, my lord, of the definition, which is, my lord, called out here. My lord, the only reason why we wanted to be implemented immediately before the NGT is, my lord, we wanted to show a coordinate bench decision of the NGT where the NGT has held that if there's an issue of challenge of conversion,
Right.
the forum is land tribunal.
Very good.
NGT does not have a jurisdiction.
To say that
I
tribunal,
have that judgment, my lord. I'll hand it
the
over. Kindly
proceeding
pardon me.
drop.
This is NGT judgment, my lord.
Mr. Bag, you ask your clients.
We will go, my lord. We'll on the 11th, my lord, when this is
Right.
to be heard.
Yes.
We'll place this before the NGT. my
You
lord.
place it if NGT the OA application goes, then
That
the
is what,
court
my lord.
order-
That is the reason, my lord. I'm sorry, my lord. This is an NGT order.
No, no, Mr. Bag, we are not being to because this is an admitted fact that, as my brother points out, that it is emanating from the same rudiment. So when this was not done by
May
you
only-
for whatever reason,
May I very humbly submit this, my lord, subject to consideration by your lordships. But this is, in my very respectful submission, from two different aspects of the matter. NGT is, my lord, where an individual files a complaint saying they don't have the conversion, proper conversion. They are filling the pond without proper permission. That's the NGT proceeding, my lord. Where the challenge is this, that hence our rights under the act is affected, you please take cognizance. We are carrying on the construction, they come and stop the construction. We say you can't do that. For, my lord, then we approach, because we have the rights, my lord, we have fulfilled.
Why did they say you can't do that?
Why did they say that?
They came and stopped your construction.
My
Why?
lord.
What was the reason?
According to them, my lord, we don't have permission. That's their grievance.
Right. So it's the
There are other grievances which I cannot, my lord, indicate. This is the reason. They wanted us to do something, we did not do that. So that is the reason we could not. And we say that we have everything, we have done everything in accordance with law. We have the conversion certificates, we have every step we have followed the law. So why will we be punished? We come to know of that order, we file for impleadment.
he would have thrown out his petition had you shown us that on the date you went to the tribunal, you should have told the writ court one line you could have taken.
May I indicate this? May I indicate this, my lord? From the April order, we are aggrieved because of the writ. That's the genesis of the writ petition. That is why I said, my lord, the two proceedings are separate, because the genesis of the writ is from that order of 144, which is an April order, my lord. That's an April order. That is the genesis of the writ petition. Where, my lord, our case was that we are not able to proceed with the construction because of this reason. Today, my lord, they have not filed, they've chosen not to file a suit against us for injunction because of, my lord, the limitation under 41H. May I read that, my lord? 41J. Injunctions when refused, an injunction cannot be granted. J states when
This
the
ought to have
plaintiff
been
has...
argument, this argument which you are advancing ought to have been before the single judge.
With single judge, in my very respectful submission, my lord, my premise was, my lord, that this order is not being given effect to, which is at page 335.
Exactly.
That is my case before the, my
No,
lord, single judge, honorable single judge.
The court had you brought this fact to the notice, court would have negated their contention. Finished.
My lord,
Lock, stock, battle goes.
I understand that, my lord. Here, my lord, 41 of the specific relief act says,
I
my lord,
think
J.
this, subject to what you say, Mr. Bag,
My lord.
you sit with your clients and decide.
May I only...
We are prima facie, we are not satisfied with the reasoning given by you for non-mentioning this fact before the writ.
I'm indicating, my lord, kindly give me 5 more minutes. I'm sorry, I'm troubling your lordships. 5 more
Not
minutes.
a question of trouble. We were thinking that we can sort out the issue, because once you can show the conversion done, once you can show the compensatory pond has been constructed,
That we have shown.
once this you have shown to us,
My lord.
if this is shown to the tribunal backed by a similar order which has been passed, we don't prima facie feel that there will be any necessity for continuing with that proceeding, or for that proceeding your crores of money cannot be stopped.
I'll show 2 documents before I go to the law. I'll indicate that, my lord. May I only indicate?
Yes.
Only indicate this, my lord. My lord, today, my genesis of the writ petition was
Is
page
the
335.
executive magistrate order.
Where, my lord, the observation is that they will keep a vigil and maintain law and order, which was not being done, my lord.
Now you have got an additional protection. You
We
have
have
been
that
allowed
reason.
to continue with the protection.
And I'll indicate, my lord, the reason. Because, my lord, they did not file a suit against us. Because, my lord, section 41...
How the trial judge will know that suit is maintainable, no
my lord,
maintainable?
I'm not on that.
You have not advanced this argument.
No, my lord, that is
Sorry,
my
Mr. Wag.
that is my case, my lord. Kindly give me 2 minutes, my lord. 41J says when the plaintiff has no personal interest in the matter, so they can't show that they have a personal interest in the matter. That is why no injunction they can expect. They know this. Then, my lord, kindly note this. Kindly see the order, my lord, which is under challenge at page 688, volume 3. Your lordship has gone through the order, my lord. May I only indicate that once. Volume 4. Volume 4, my lord, page 688. The order impugned
Of the single judge.
of the honorable single judge.
Yes.
Your lordships have gone through it. My lord, kindly see The second paragraph, third paragraph, my lord. This was not given to us. We came to know it in the proceedings, my lord. The state has submitted a report. Kindly see this part, my lord. The report contains the inquiry which was conducted by the inspector in charge, Rajarhat Police Station, wherein it is admitted that proportionate area has already been converted. So the state has said this into a pond in respect of the area for which construction is being raised by the, that was the main grievance. Having regard to the said fact that the police authorities are having knowledge regarding the incidents which have been reported and for which the petitioners are also aggrieved, I am of the view that the police authorities would keep a surveillance and ensure that the petitioners be not obstructed or any untoward incident results because of continuation of work of the petitioner. I pause here for a moment. My lord, here today, if your lordships are minded, my lord, to remand back the matter, then, my lord, it will be implied that they have a right to appeal. Otherwise, my lord, the appeal is carried by them. So either, my lord, if your lordships are, my lord, pleased to remand back the matter, kindly consider one decision, and I'll place my arguments on this. My lord, this is a 3 judges bench in 2020 on the definition of, my lord, who is an aggrieved party, who is an aggrieved person. Paragraph 19, 20, and 21, 3 paragraphs I'll refer to. The onus is on them to show they are aggrieved party. They can't be an aggrieved party in this proceeding. It was police inaction which we had, my lord, challenged. An order on the basis of a report filed by the state.
Sorry, Mr. This is
Lord,
2020, volume 9.
2020, volume 9, Supreme Court cases 501.
Who are the members in that fact-finding committee?
It's headed by the district magistrate
And a scientist.
and senior scientist from the West Bengal Pollution Control Board. As the
And
special
that is,
requirement.
your case is returnable on 10th July.
11th of July, my lord.
My lord, in fact, my learned. Last day when the matter was before the Honorable NGT, my lord, my learned friends did not appear. So, my lord, today the difficulty is, my lord,
You have been caught on the wrong foot.
my lord, perhaps we have not been caught on the wrong foot, my lord, because
Just one disclosure, one line.
disclosure.
That's all.
Problem
They would have
solved.
been out. They would have been nowhere.
The 48
That's
crore
what is
property.
bothering us.
we are,
Each and every day you are suffering.
my lord, we are.
You are suffering. And your,
And we have all the certificates which are required by law. We have everything in place. We just have to place that those certificates before the Honorable
exactly,
Tribunal.
that is what we are telling you.
We will do that.
Exactly.
On the next day, we'll do that, but not the Honorable Single Judge, because, my lord, here the premise in my very respectful submission was different. It was from, my lord, an order where, my lord, there was a direction on the police authorities that you maintain peace and you see that no, there is no untoward incident. Still, it was happening.
There was no direction for continuance with this construction work.
No, my lord, it was not there. But, my lord, there is also not a
That
stay.
is the
My lord,
addition which
kindly appreciate this, my lord. There was no stay.
So far as maintain peace in the local, up to that it is all right.
My lord.
That because they will come and create obstructions, they will heckle your officers, etc. Up to that, magistrate's order, subject to the legal niceties, was acceptable. But when, after knowing everything, if you don't tell the court, maybe the court would have thrown out their objection at that stage.
But may I only submit this? My lord,
And
today,
court has said that no, this is the police report. These are the hooligans which are disturbing you, so you allow them to continue with the
because I'll also indicate, my lord,
construction completed, third party right comes into who will go into
it's a project which will take, my lord, it's a construction project which is, my lord, of immense, my lord. It's not a matter which, my lord, we can
You stay your hands till the 11th. Go
But
before the NG.
kindly don't, because I'll tell your lordships why. This is my submission, my lord. There is no order of stay from the NGT. There is no order of stay from any, my lord, competent court.
So that's why we are suggesting it to you that we won't pass an order of stay, lest it prejudices any of the rights of the parties. So you stay your hands.
It will be an impliedly, my lord, it will be an order on us. My lord, without, it will be an order on which we will suffer. But when we have every, my lord,
to help you, Mr. Bach.
I understand that, my lord. We'll come back then, my lord, after the 11th. Kindly permit us that. But before that, may I only indicate one point of law, my lord. I'm trying, my lord, to canvass my submissions. I know, my lord, I should have, perhaps I should stop.
Rajarat police station.
Who was appearing?
Who's appearing for that?
Oh, state was there.
Mr. Banerjee is appearing. Mr. Banerjee is, yes, yes.
I'm no longer there.
Yes, Mr. Banerjee.
My lord, may we take instruction? I've understood what has fallen from your lordships. May we take instructions and come back on Monday? But before that, my lord, may I also place this judgment on record, my lord, only for this reason. Today, if your lordships are, my lord, minded to, my lord, consider the leave to appeal, my lord, my learned.
Just one second. What you are wanting from us?
Lord, I
Today,
think
suppose NGT sees these documents, fact-finding report, and says that no, they are not at fault. There is no environmental issues. Your complaint is not entered.
well, let them stay their hands, my lord, till the 11th, my lord. Let it be adjudicated before the National Green Tribunal. Because, my lord, the NGT, my lord, it had within its domain of knowledge the fact that there is a conversion, my lord, which was already, my lord, given by the district magistrate. Now, whether the conversion was given in the right way or not, whether, my lord, they proceeded, the authorities
So the
proceeded in rocket.
NGT, in spite of knowing that, the NGT did not stay.
No, it constituted a fact-finding committee, my lord. And, my lord, the intervention application, the implement application, filed by my learned friend's client, my lord.
What are the contours of the fact-finding committee?
We are waiting. That is, my lord, had the fact-finding.
What fact will they find?
My lord, the scientist and, my lord, the district magistrate, well, they will submit the report as to whether the conversion which has been granted, whether it has been granted in consideration of all the materials or not. This is one. Second is, my lord, the scientist will, my lord, base his report, my lord, on the flora and fauna of the area, my lord.
Where do you find that?
No,
Where
that
do you
is the
find
fact finding. That is one of the.
That's your interpretation.
No, yes, that is my interpretation. That is my understanding.
Not there in the order.
No, that is my understanding. They are rustic villagers, my lord.
No, the DM and the scientists are not rustic villagers.
I say, my lord, my clients, my lord, they are the villagers. They have, my lord, approached before the authorities by way of letters. Now, as to whether what the NGT is adjudicating is, my lord, as to whether the conversion, because NGT goes on to record that the district magistrate has granted a permission of conversion. Whether that was done in the right way or not, my lord, that is, my lord, for that, my lord, the fact-finding report will be necessary. Now, had the fact-finding report been filed on behalf of the state, my lord, and the Pollution Control Board on the 19th, everything would have been clear.
State's report is against you.
The police's report is against
State,
me.
not police. State report.
State.
That's what's recorded in the order.
My lord, state means, my lord, the.
State means state.
No, it was, my lord, the IC. The IC of Rajarat. But the honorable single judges.
Yes, see that? It says state has filed a report.
Yes.
State.
Yes. State has submitted a report. Report contains inquiry conducted by the inspector in charge, Rajarat. So they basically append it to the report, the inquiry report, and that is constituted as considered to be a report. My learned friend will be having a copy of the report. We do not have it, my lord.
We don't have a copy.
No, because it was ordered in the order, my lord. It was yes.
It was given.
It was categorically stated.
All right.
will not
You
be given.
finish up which judgment you are relying, Mr.
Lord, I've handed over, my lord. This is 2020, volume 9, Supreme Court cases 501, paragraph 19. This is internal page 8 onwards, my lord.
Psychological, I like that word.
My lord.
Psychological harm.
My lord, it is the expression.
Imaginary or
My lord.
psychological.
Paragraph 19, my lord.
সুকুমার মুখার্জিকে ওই পদ্মভূষণ দিল।
The expression, internal page 8.
Yes.
The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. And then paragraph 20, my lord.
Yes.
The court laid down the test to find when it would be proper to grant leave to appeal to a person not a party to a proceeding against the decree or judgment passed in such proceedings in the following words. Over the page, my lord. Now, what is the test to find out when it would be proper to grant leave to appeal to a person not a party to the proceeding against the decree or judgment in such proceedings? We think it would be improper to grant leave to appeal to every person who may, in some remote or indirect way, be prejudicially affected by a decree or judgment. We think that ordinarily leave to appeal should be granted to persons who, though not parties to the proceedings, would be bound by the decree or judgment in that proceeding and who would be precluded from attacking its correctness in other proceedings. Applying the above tests, and what it is held that in this facts, they are not person aggrieved. That's paragraph 21. Paragraph 21 stated, not applying the above tests, we are of the considered opinion that the appellants
Yes, miss.
But may I also, with apologies, may I only indicate this. This is something, my lord, which we will show this judgment before the NGT. But I only want to, my lord, bring it to your lordship's kind notice. It's a one paragraph, my lord. This is an NGT Bhopal, same coordinate bench, my lord. States that if it's the issue of conversion that you are challenging, then NGT is not the forum. So my first point in NGT will be this is not maintainable. And there are several judgments on this line, my lord, that this conversion, this is the second paragraph, my lord. Second paragraph, my lord. All these matters pertain to allotment of land by the state authorities, enforcement of second paragraph, my lord.
Yes.
Rajasthan Land Revenue Act, mutation of the land, permission of competent authorities for conversion of land, proper demarcation of state land, which is within the domain of state authorities, revenue authorities, and appropriate remedy is to file an application before the revenue authorities. If applicant is agreed by any order of the revenue authorities, the appropriate remedy is to file revision or appeal according to the rules before the appropriate authority, forum or appellate authority. The matter involved and rights sought in the prayer clause is beyond the scope of Schedule 1 of NGT Act. The applicant has alternative remedy for filing the appropriate application before the revenue authorities. It was not entertained, it was dismissed. The issue here is conversion. They say that you have
Yes.
And normally the other difficulty we are facing, because there's a direction from the NGT that, my lord, my learned friends have to file opposition to, my lord, our application which we have filed. If they do not file that opposition, my lord, that application for impleadment will not be taken up. So, my lord, we really do not know on 11th, my lord, what will be our fate. And today, my lord, if we stay our hands, I'll take instructions if so falls from your lordships. But if we stay our hands in the construction.
We are not asking you to, we are not putting you in any embarrassment.
No, I
It's
understand.
just we are
I
speaking out of.
But because every day, my lord, if we stop the work completely, it's a huge commercial aspect, my lord, commercial impact on, my lord, us.
We pass our orders.
This is only, your lordship is hearing, my lord, the leave to appeal.
Yes.
My lord. These are my very respectful submissions, my lord. I'm very deeply obliged.
No, Mr. Bag, I was wrong. The order which we pass, whatever way it goes, naturally nothing will remain to be decided in the appeal.
My lord. My lord.
Now, why you are saying, Mr. Bag, to restrict our order only to leave to appeal?
Because I've made my submissions on
Leave
the
to appeal.
leave to appeal. So
What
if
we have
that is
minded to, we only leave, if the leave to appeal application is allowed.
then the appeal has to be heard. I have to put facts on record, my lord.
Right, but if we send it back on remand, question of keeping the appeal before us does not occur.
My lord, if your lordships are pleased to send it back on remand, then my lord, upon allowing my very respectful submission, my lord, upon allowing the leave to file appeal application, you kindly permit me an opportunity to place on record the facts which will, my lord, demonstrate that they can't really file this appeal. This
Place
appeal
the
cannot
facts
succeed.
before the single judge.
So that's the scope of that writ petition is very different. That's my submission. That I'll indicate, my lord. Once, if your lordships are minded, my lord, to allow this petition,
Yes,
3A1.
you add them, you get their grievances on
The
record. You file
difficulty
your
is, Lord, then
application.
I'll also make submissions before your lordships, my lord, that if this is remanded, my lord, this writ petition, which is a police inaction writ petition, my lord, if this remand is permitted by your lordship, then, my lord, I have to indicate a few more facts which will I'll try and canvass, my lord, that this should not be remanded. I'll indicate that. That's really my very respectful submission, and subject to being considered by your lordships, my lord. Because I've not made submissions on that merits part, where, my lord,
We are not going into the merits.
my lord, remand, if your lordships
We will
are minded
observe
to
that
remand.
we will observe that we will observe that his presence or was necessary.
I'll indicate, my lord, what is.
So if his presence was necessary, the matter has to go down in remand. There is no other option. Or we have to, you are asking, if then we considered on merit, we have to pass some order, no?
May I only indicate this, my lord. Today, if your lordships will not pass an order, my lord, that they should be heard. My lord, our submission is, my lord, the writ petition is, my lord, moved by us. They are neither
on a
proper,
different
my lord,
premise.
I'll indicate, my lord, they are neither proper nor necessary parties there. They don't have a locus. That is my case, my lord. They cannot be an aggrieved party. They do not have a locus. And that is the reason, my lord. I'll tell your lordship
Very
what will
good,
happen
then
then.
you complete your arguments. We are not going for affidavits. We will take, because unnecessarily we
But there
have
few-
heard the matter. We have heard the matter.
May I only indicate this, my lord? If your lordships are my lord.
We will not stop you from arguing, Mr. Bag. But the thing is that
No, I'll not waste your lordship's time, my lord. If it, my lord, if it.
No,
I should not do that.
wastage of time. We have now. If we exchange the pleadings, then it's question of grant of interim order comes. Naturally.
Today, my lord, first, this is my submission, my lord. First, they have to satisfy. Today, according to us in the writ proceeding, they are neither proper nor necessary parties. That's how we have proceeded, my lord. That's the, my lord, because they don't have a right in the entire matter, my lord. They are not, there's no locus that my learned friends have. Today, my lord, that is the reason they are not instituting a suit, because lord, if they do, there's a bar under 41J of the Specific Relief Act.
Yes, Mr.
Effectively, my lord, then what will happen is, my lord, this order goes, my lord, the order passed by the Honorable Court goes. They will use this to show, my lord, that today, my lord, the difficulty, then, my lord, they will have a right of audience before the Honorable Single Bench, my lord. They'll have a right of audience, which means it will be.
Stop them from having audience. You say that they are not a necessary part.
But then, my lord, it will be.
We are only minded to send it back on the ground that this we think ought to have been brought to the notice of the learned single judge. We are not going into any other issue. That the date when it appeared before NGT, on that date you affirmed the writ petition. You did not write a line to that effect. Matter was heard on 20th. That was also not told. This does not. This means that you are. Let us see what happens. Sort of an attitude. You go with that. We will find out. They do not have. I don't know what will be the result of the NGT. But what you have pointed out before us, these are weighty grounds. Why the NGT will interfere into this?
NGT, my lord, will argue. That is my case, my lord, that we have a different case before the NGT. We have a different case before the High Court. But the Honorable High Court, the case is that there's an order which was there. This order was not being
That
followed.
will be the trial court's due. Trial court will see whether the NGT pending proceeding has any nexus with the argument which you're advancing in
There are
writ.
few points which are troubling me, my lord. I'll be candid, my lord.
Then you
And that is
finish your
that is the
argument.
reason, my lord. May I come back on Monday? I'll tell you, lordships, what is troubling me, my lord. The order, my lord, the proceeding which we have filed from, my lord, in the before the honorable single bench, my lord, that emanates from that order of 144.
We have
But
heard
the
you, Mr. Bhatt.
But we have not indicated there about any proceedings before the NGT. There is, my lord, because that's the genesis of the writ petition. In that proceeding, my lord,
We understand your argument.
today-
Your argument is that I am not required to tell this to the court because my writ petition arises out of something different.
and in that different proceeding, we have not indicated any of this, my lord.
All right, you come and make your arguments. We
We'll
will
do that on
pass
Monday,
our
my lord.
orders on Monday. Monday you finish up, you pass up.
Very
When you tell us how long will you take, we will hear you on this thing because
I'll not take more than 15, 20 minutes. my lord.
very কালকে সোমবার কি ও সোমবার তো প্রাইমারি ম্যাটারটা
I am a very small fly, my lord, only one matter.
Look like you're a small friend.
Go 20. I look big, but I am
26 থেকে
26 তারিখ 26 তারিখ কেন 26 কোথায় যাবো
এরকম ভাবে ফিক্স
ও ঠিক আছে
26th at 3 p.m.
Very deeply obliged. Very deeply obliged.
On 26th as fixed at
But it may file the affidavit of service for it.
ওপরে evidence of service, as file, be kept on record. For orders 26, 3 p.m. 3 p.m.
দিয়ে দিয়েছে
You're right.